Oh, we're almost done.
We have a list of numbers this way.
Have it with me right at the moment.
Oh.
What do you need?
That's for live with what it's for. That's fine.
All right.
Let's
go. All kinds of people here now. Yeah. Good. All right, I'm gonna bring the meeting to order. Dawn Berube from 135 River Road.
Mike Wayne, Select Board Rep.
I'm Carrie Mackinnon, the Community Development Director.
Adam Sandall, 9 Edgewood Drive.
David Glazier, 80 Peasley Road.
Kip McDaniel, 117 Page Road.
Mike Lawton, 3 Asa Drive.
Sandy Crystal, 1 Shoreview Drive.
All right. So getting right into it, I may take this out of order a little bit. Is anybody here to speak on behalf of the changes to our road standards? The first thing on the agenda? Here we come, because I'll save it till afterwards and just a little early time. So with that, we're gonna move on to in public hearings, number 2. Application 501-23, Strategic Contracting Company LLC, continued from 4/20/2023, major subdivision for a 5-lot residential subdivision located at 178 Wood Hill Road, Hooksett, map 43, block 2, lot 43. Who do we have presenting?
Good evening, my name's Tim Bernier, CF Bernier Incorporated. We're working with Strategic Contracting. We left the meeting 2 months ago. The board was going to get some insight from town council. I can present the application, or I don't know how you want to go. The attorney is here for Strategic, spoke on the issues.
Yep.
Yes, we'll take your lead.
Okay, so with this, the big question that the board had is there's notes on the plan from the last time that this was subdivided, and one that it would be the last time, or that, you know, wasn't to be subdivided again. Which and now we're here wanting to subdivide it again. We did hear from our attorney that the gist of that, yeah, if you would,
I mean, the information received from the attorney you discussed in non-public session last time.
Yeah.
That's, so we can't disclose that.
okay. So I guess part that I'm still struggling with is, you know, to go, yeah, that wasn't very clear on there. You know, we actually did hear some from past chair, I think that was on here, or at least on a board member that, you know, they felt pretty strongly about not wanting to subdivide anymore, and I struggle with, you know, going against the past plans. I mean, that first time, you know, they put it with that contingency to not subdivide again, and, you know, so, you know, we're gonna do it this time, and that's it, which I don't know. if the
And there are
board
some
had-
additional concerns from other departments like the fire chiefs.
Yeah, and that's, I mean, and it's, the main reason is, you know, our safety concerns of, you know, too many houses on a single egress.
I wasn't here for the last session, so I apologize. I wasn't here for the private session. But then the session before, we had said, I think I'd raised that it's very clear that this is there. And I seem to remember they were asking us to grant waivers and they would sort that out kind of thing. Was that am I remembering that correctly? Has anything changed since then? Are they still asking us to grant waivers in anticipation that they might sort out this issue of, I'm using loose language, but in the deed, it says don't subdivide again.
Especially on the plans, right? The subdivision plan is where that language is.
So what has changed since we sort of,
I'm not sure.
I mean, I guess we'll-
Their attorney was going to try and sort that out with
Yeah.
Merrimack County deeds and how we go about advising the plan and things like that.
What has changed?
Question.
So, for the record, Patricia Pansiaco for Strategic Contracting. To answer your question quickly, nothing really has changed. What my client's deed just references the plan that has that teeny tiny note that some of the board members couldn't even find because it's so small, that's on the plan that says no further subdivision. That's the only thing, and it is part of his chain of title, but that is the only thing that is a problem for my client. He owns 41 acres out there, and we realize, or our belief is, it was an unintentional error, but it is a private restriction now because we can't open it to the public process again. The applicant has been unwilling to allow us to do that. So to take that note off the plan or find that it doesn't apply to any lots that this board may consider approving under the current application, that's our problem to resolve unless the applicant for the prior plan that caused it to be there was willing to allow us to reopen. I think that was the town attorney's opinion a couple of years ago. I don't know if that's changed. But I did provide you a lot of information last time we were here.
Yes.
I gave you the history of all the lots created on Wood Hill Hooksett Road. And I did want to revisit a couple of things. And I brought some, not like last time. I did bring a couple of things that I found in my research. This one here is a summary of the history of Wood Hill Road. And it was done by Bill Clubbin in 2003. I thought you'd find it interesting. And if you want, you can, there's 8 copies there. The regulation that we're talking about is 3.02B. And it was adopted by the planning board, I assume, in 1979. When it was adopted in 1979, though, there was already 18 lots on this road, which suggests to me that this regulation was never intended to apply to existing town roads. Now, the reason I say that also is if you look at the history of Wood Hill Road, before this was adopted in 1972, the town voted at town meeting to discontinue the center 1.2 miles, the center being between Allen Road and Bog Hill Road. All this information is in that packet, so you know that I didn't just dream it up. In 1975, there was a Warren article that looked to put part of that into a scenic road. But when the research was done, they couldn't find the vote, whether it passed or not. So I don't think that they consider this a scenic road. In 1978, they tried to discontinue the road, and that was voted down. But the town did stop maintaining it in the center portion there, is my understanding. And it's a class 6 road all the way through. And it's become class 6 from non-maintenance, not because of town vote. So whether it's class 6 or class 5, it's still a second access. You can think about, I understand.
I think the fire chief would disagree with that, but
Okay, and you know, Mr. Chairman, you mentioned some concerns expressed by the fire chief. What were they? We don't have those.
They were online, I know. I read them earlier today, basically secondary access. You had them? Or-
I had asked for those today. Any kind of comments since we were here last March and
I don't think they were
I think it was-
beforehand.
Right, I think they were provided at that time, or they were done at that time.
Yeah,
They were new comments.
were they from 2021? Because in 2021, he had no problem and neither did the police department when we first came. So if there's something new, I think we would need to know that.
They're from March, from the previous meeting, so.
Okay, do you have, them?
Signed it March 6th, 2023.
Tim doesn't have them either.
Okay.
So back to what I was saying, in 1979, when this regulation was adopted, there was already 18 lots on the road. There's 32 now. After it was adopted, the planning board either overlooked it, ignored it, or felt it didn't apply because it approved the 6 additional plans, the subdivision along this road.
so in those plans, actually, were they lots that were divided into two, or were they, lots that were multi-lot
To a,
subdivision? I'm just curious.
okay. I have that with me.
I know, like this lot was, okay, go split it.
Okay, the first one was 3 lots and it was way down at the end. This is bigger. This is Bog Hill Road here. These 3 lots are ironically the furthest ones in from Bog Road. The second ones were up here at the end, as with the third, and those all predated this amendment being adopted. The fourth ones are down next to the originals, 3 more. Then you've got the 5th one, which was down here, 2 lots beyond the original first 2 in the 4th 3. The 6th one is 3 more lots right about the middle, directly across from my client's property. And the 7th one is a little further down. The 8th one was up here, closer to Bog Hill. And then the 9th one was Mr. Jolica's lot in 2004. But there's also been another subdivision since then I think it was 2017, done by Holden. And that was up here, it was number 8, where they had that road that was shown on a plan and it went away, and I don't know what happened, but that got approved also.
With
Ah.
the 2 lot subdivision.
I think, I don't know how many were approved, but this history seems to suggest that at least the planning board early on who adopted this perhaps didn't intend it to apply to an existing town road. I mean, if you think about it more logically, an applicant has no control over a town road. But with new subdivisions, the applicant does have control over providing a secondary access. And it's certainly within the board's authority to say you don't get a second access, you don't get your lots. It also,
It's much easier on a new,
well, easier, but from a control standpoint, if you think about it more broadly, an applicant does not control a town road. So how would an applicant have the ability to provide a second access? It just doesn't make sense. And not for nothing, this road is a through road, and it's the town that decided to not maintain it anymore. So in that way, it's created a single access road by letting it fall into class 6 status. Although there's been evidence and testimony in other minutes stating the contrary, that is very passable, at least for 10 months of the year. So when something like this happens under the law, and I'm sure you've all encountered a rule or a regulation and you read it and you go to comply and somebody says, well, that's not how we apply it. I'm sure you've all encountered it. That's called an administrative gloss. And what that means is the person or agency, whatever, charged with enforcing it, they interpret the language in the law differently than someone else would. If you look at this regulation from an objective standpoint, it says in the language, any road serving more than 12 lots shall have an approved secondary means of egress. It doesn't describe what kind of road, private road, new road, existing road. And it does not tell you exactly what is required for secondary access. Then it says, and of course, this is counterintuitive too, the classic of the single access road limits the cul-de-sac, which is typically the way these are controlled, not by counting lots. Because if you think about that,
Say that again.
most towns, if they're concerned with what was referenced earlier, fire access and emergency vehicles reaching homes along the road, they don't limit the number of lots. They limit the length of the road, and they say 1,200 feet is the maximum single access road, okay, cul-de-sac length. They don't say 12 lots. In theory, you could have 50 lots in here in any length of road, and that's further away than you would have with a cul-de-sac limitation. It just doesn't make sense. I don't, and we couldn't get to the bottom of it as hard as we tried. But this particular provision, any road, it doesn't say what kind of road. It raises an ambiguity. But this board has always and historically applied this regulation to mean existing roads if I look at what they did here. Because subdivisions have continued to occur since the day the regulation was passed in 1979.
I have a question. I think it's the same question I asked last. I'd love to know there's a different answer, which is the road seems like a red herring to me. According to our background information, when this property was sold,
Mhm,
it says it could not be subdivided again
mhm.
with a secondary egress. So whether or not the town let the road fall into disrepair,
Mhm.
whether or not it kept on subdividing and subdividing and subdividing. That seems to not be the point that bothers me. It means that someone bought this property knowing or should have known that they were not allowed to subdivide it again because of certain rules, because they couldn't do anything. So I know that we want to discuss the road,
Mhm.
but why should we ignore the rules under which this property changed hands?
Okay, that became a private deed restriction by referencing the plan in the deed. It's not your job to enforce that. That's our problem.
Oh,
And my question to you as a board, put that aside for 1 second and I'll come back to it, okay? If that note were not on the plan, the one that my client didn't see, Mr. Day wasn't told about, and I hope you've all gotten a copy of the affidavit that we sent over from Mr. Day, where he learned about it when he showed up at the meeting the night. He knew nothing about it. And in fact, his attorney couldn't find the note on the plan when he was helping Mr. Day prepare this affidavit. And the last time I was here, there were people on this board that were asking, where is it? Because it is so small on the plan.
Well,
That's my problem
So
to
with
resolve
that,
though.
But if, when the planning board puts a restriction on, you can subdivide this, but it needs to be noted on the plan that it can't be subdivided any further, which applicant agrees to. How tiny or how big they put it on the plan isn't the planning board that, make sure you hide that in there, so
No,
an uninspected buyer, doesn't see it. this board said, you know, we'll grant a waiver to subdivide this lot, you know, under the condition that it's not subdivided again.
You don't have authority to do that. That's an unconstitutional condition. You took away somebody's development rights.
But everybody signed it though. The owner signed it, the planning. board
Remus,
signed it.
Mr. Day signed it under duress. He didn't know about it until he showed up for the meeting that night, when the board was looking to approve the plan. But that's our problem.
Well, he signed it under duress when?
His mother was sick. He needed the money to pay the bills for her care. And he wasn't going to be able to sell the land, the lot that had been subdivided to Mr. Joliker without signing the plans. That's the reality. That's what Mr. Day has said under oath. So but notwithstanding, what drove that was
Mr. Day is,
the former owner of the property. But even before that, the board, whoever was on the board at the time, brought this up and tried to impose it on an existing town road. That's unconstitutional. I'm telling you that right now. It's a taking of somebody's development rights. And it's something that we have to deal with. We are assuming the board would not disagree that maybe that shouldn't have been done. It was not done to anybody else. And we will deal with that. But if that wasn't there, would the board waive this provision, as it's done for all prior applicants, and allow the property to be subdivided, subject to the approval?
This is a process. Are you asking us to grant a bunch of waivers?
One waiver.
Sorry, one waiver pending resolution of this in the
Yes.
courts? Why don't you go to the courts first and resolve it and then come back to planning board?
Because we decided we were gonna come this way first. We were hoping to be able to reopen the case, but we're being held hostage on that regard.
I think that's where we left at
Yes.
our last meeting, was you resolve the legal issues as to the posting on the plan, or the note on the plan, and then we would consider the waiver. I'm pretty sure that's where we left it.
That was my
Yeah.
deja vu.
We're not going to incur the cost of going to court because it's not going to be inexpensive to resolve
Mhm.
on the potential that the board would grant the waiver, because we may very well be successful in that and come back here and have you say no again.
I would.
I don't know.
We're the cheaper.
I would.
Yeah, well,
I'd
yeah.
like to add something
Yeah.
as well. So just to be clear, so this issue with this note on the plan, the condition of approval. It didn't get caught as a title flaw. The title company did title research, said, nope, the plan's good, no problem.
Yeah.
We didn't know about it. Before my client bought the property, I came in and talked to Matt Taylor about this dead end road thing. And he said that does not apply to class 6 roads. And he said that it did for a little while. He understood that there was a time when the town did it, but they were very inconsistent. And he said that the town does not take roads that were through roads that became dead end roads by discontinuance as being subject to that condition. So they bought the property based on that statement from Matt and the fact that nobody was aware of this title defect, which the title company says isn't a title defect because it's private or it's something else. So that's why they didn't mention it. So that's how it got through, and that's how we got to this point. So the question is, so when we submitted the application, I did not submit that as a waiver request. That was submitted later
That's true.
as a counsel for my client said, well, maybe we should submit it just in case. So it was submitted after the fact as a backup, I guess. So the way that I looked at it is we could pursue this subdivision. And with this legal issue that's kind of overhanging everything with this note on the plan. And I think the argument that the Pat is trying to make is that this is a private issue that they have to get resolved.
Mhm.
And it doesn't really affect the planning board. Action.
Right.
So I guess, there's a lot of discussion of, does this section even apply to this road? You're kind of leaning, the board's kind of going both ways. It does or it doesn't. We haven't kind of even gotten it.
And you make a very good argument on why it wouldn't apply to this road.
Why it would or would not.
That, why it would not, because it was an existing road and it's probably the same argument why so many subdivisions have got done in
Probably.
trying to limit the subdivisions. That we had a subdivision that was agreed to that, we'll subdivide it, but it can't be subdivided further. And that's for me, that's the biggest hurdle of it. As far as arguing whether you can subdivide on that road is a different, you got two different things. You have, subdividing a lot that doesn't have, that hasn't been subdivided with that placed on there, that, this is it. Or.
I-
That's,
Like, and correct if I'm wrong, but I feel like you have two legal issues on the restriction of subdivision. So if the planning board instituted that restriction, you have an argument that that's an impermissible thing. But secondarily, there's also a private, that's a more a public issue, not for the board, but a public law issue. Then you also have a private contractual issue with whether or not that was constitutional. They still sold it to you with that provision.
I'm not following you on the second one.
So if they said, forget the board being involved, if they said you can't subdivide it and you bought it,
Mhm.
you have an issue with them. But you,
Oh, but they neither involve the board.
right,
And there are issues to resolve. What we've got now is we want to subdivide it subject to us resolving those private issues, because, and then I just thought of this, the first question the court is going to ask me, did you exhaust your administrative remedies? I'm sure you've heard that before. Did you go back to the planning board? And yes, we've been trying to work this out now for 2 years. And council told the town when we were here in 2021 that the applicant had to agree to open the case where it was imposed and then bring that back to the board. But as I explained, they're unwilling to do that. So we'll have to go that route to deal with that. As far as what's before this board tonight is the subdivision of the 41 acres. And it's only going to be valid for us until we clean up the title matters with the court. So we're asking for a waiver.
Or
the
or not.
extent that- or it
just
doesn't
the
apply.
Determination that it doesn't apply.
And
This would help us out a great
Mhm.
deal. If the board determined that yes, what we were told and the fact that the board has routinely not enforced this regulation on subdivisions on class 6 roads that were made dead ends by discontinuance,
but,
not by creation.
was
That this did not apply to those roads. It kind of makes sense. If you think about it, there's a lot of these roads in town. And if you think in 1979, the people that owned 50 acres on those roads with we have this has over 1,200 feet of frontage and was 50 acres. Do you think, and there was a bunch of those people in town in 1979, if they thought that this regulation was going to apply to them,
Mhm.
that said, okay, you own 50 acres and you got 1,200 feet of frontage on a class 5 road, but you're not going to be able to subdivide your property because there's already 12 lots on your road. Do you think that would have gone through very well? I've been a lot of small towns and I'm thinking there've been a lot of very upset people. So my guess is in 1979, if they were probably told, no, it's not going to apply to existing roads that were discontinued that created the dead end. It's for new subdivisions that are taking 50 acres and building a road.
And I would agree,
Mhm.
you know, putting in a rule like that to be on new roads.
Yeah.
new
So that helps us to understand that hurdle. So that's one of the two hurdles in whether or not there was a need for a waiver.
Right.
Then the second half that I think this board needs to decide, a little bit tougher decision, and I think you hit it right on the head, is this board willing to go forward with a subdivision application, knowing that a prior board put a condition on? Because if that waiver isn't required, then we can move forward with the subdivision with the one caveat that this board has to be comfortable moving forward with the subdivision with that known piece of information that there was a condition put on.
That's my biggest concern is, you know, the board put that condition on it, the applicant agreed to it, everybody's. You know, it was recorded that way. You know, and it was finished. So that's the part that I have, well, they didn't really mean that, or, you know, I struggle with that.
But that's my problem, not yours.
Well, it is our problem.
Well, it really
It makes
isn't.
it our problem.
If you approve to the subdivision, subject to us having that note expunged, and we were unsuccessful, we lose. Town doesn't lose. There's just no subdivision. But I find it really difficult because this is wrong on so many fronts.
Mhm.
To believe that this will not go away. It won't impact anybody if it goes away. And when there was discussion of restrictions in the past, in all the minutes, it was only when there was no potential for subdivision any further. Here, there was 41 acres. And they were over a barrel because they didn't know about it until they came in and met with the board. They weren't told about it ahead of time. And at that point, they really needed to sell that lot. That's what
Is there any history on why that was even put in? Why that restriction was put in by the board?
you mean the regulation?
No,
The.
no,
No other restriction to further subdivide.
If you look at number.
Because of that,
I can tell you, Bill Clubbin
yeah.
had decided that this regulation does apply. The roads that were discontinued. He made that interpretation on his own.
Mhm.
The evidence was overwhelming that prior to him making that determination, all the planners in town didn't make that determination. He made the determination that he did, and he made the recommendation to the board. Waiver in order to subdivide on this road.
Mhm.
He was not consistent with that because he was the planner when other lots were subdivided. And so he was not consistent, but when the days came in, it was 43. It was close to 50 acres at the time with 1,200 feet of frontage. You know, that may have been what it was. It was a lot of lots. It wasn't just 2 or 3 or 4. It was 5 or 6 lots that we were looking at. In 1998, when he originally made that determination.
There was a 12 on a little cul-de-sac coming.
Cul-de-sac.
Yeah, it was a lot.
So yeah, it was 12 lots in the
Mhm.
cul-de-sac off that road, and he made the determination at that time that we couldn't do that.
Right.
And that was Bill, and that was the first time that there's any evidence that anybody made the determination that this ordinance applied.
The seller knew that was on there.
We did not know until after. The seller?
Yeah.
Seller, well, he didn't tell anybody. We didn't disclose it. If that's what you're asking.
And this was 1997,
The first time that the lot was,
so you've had 24 years to solve this in the courts?
No, the note went on in 2004,
no,
Okay, so
the days were first denied the right to subdivide their property. in
1997. The affidavit that I sent to Carrie that said
And
yeah,
they-
he
the
was pretty
developer would've-
miffed.
The developer would have pursued it, I think, but
Mhm.
he had ran into some financial trouble right at that time.
So resolving what's happened already is our problem.
The days definitely did not have the money to pursue.
No.
So, and this was always the problem is that the owners, the days that owned the property, Jacqueline and her son, they never tried to subdivide the property personally because they didn't have the financial resources to do it. It was always somebody coming to them and offering to develop their property and give them money for it. So when things didn't go well, if the developer wasn't willing to follow through, they didn't have the financial resources to pursue a resolution. So
Gary?
Questions? So you keep talking about the note on the plan that was recorded. In addition, there's also recorded notice of decision that mentions the condition. So in your, whatever court action you take, it would resolve that as well.
Yes, yes.
Uh,
That restriction would be removed as what they call an unconstitutional condition. If you think about the very basic American way, everybody's supposed to be treated equal, right? And nobody can take your property without just compensation. That's exactly what happened when that note went on. They weren't treated equally because nobody else on the road has it, and they weren't paid a nickel. So for restricting the land.
Well, I think they were paid because they sold a piece of it.
They weren't paid for somebody taking their development rights.
43 acres with
Yeah,
1,095 feet of frontage on a class 5 road.
developable land.
So to me, I guess my concern about these requirements always are, as a former planning board chairman, was that a board on a given night decided that they knew better than every planner and planning board that was going to come after them, that this lot should never be subdivided again. And they were gonna put that stipulation on no matter what. The town could change zoning from 2 acres to 1 acre. They could change frontage from 200 feet to 50 feet. And that lot would never be subdividable
Right.
because a board, one given night, just decided, no, maybe that lot's never gonna get developed because we said so. I think that's sort of the crux of where I find it falls short to me in my
Mhm.
logic.
But we don't know why they did.
Yeah,
Yeah,
There,
They believed it was limited to 12 lots, even though there were 30 at the time. We don't know, and we've tried, I had poor Carrie running crazy, digging into old ordinances and minutes, and she was very, very helpful, but you can't find something that's not there. So, I mean, there's two choices. Either you find it only applies to new roads, which seems far more logical, or you grant a waiver that it shouldn't apply in this situation. And we will take care of the title concerns as a condition of approval,
so I guess the two questions before the board, just to, so we're not taking you up all night,
right?
is first, if we could get some consensus as to whether or not 3.02P applies to class 6 roads. I think the record that was presented.
6 or class 5.
It's, well, a road that was made dead end by discontinuance, I guess. is a
By
better-
lapse, it
In this
didn't
case,
go away.
correct.
It was, it's class 6.
By failure to maintain.
Yeah.
In this particular case, but I think that history, that the facts show that
Mhm.
it didn't apply to existing dead end roads that were existing because portions of them fell into non-compliant. Does this apply to that? Which I guess the direct question is, does it apply to this road? That's the first thing that we'd like to get some opinion on the board. And then the second, whether or not you're comfortable moving forward or not. And that, then we have an answer, at least we have some direction that we can move forward with from that.
so. Which we haven't even accepted jurisdiction on this, so. we can't open up that.
I object.
So.
I can do this right now. Can I talk?
No, we have to accept jurisdiction.
a public hearing in a little bit.
Yeah. So we would have to accept this
As-
before we can open it to the public.
Yep.
Because I know we got people who want to hear it.
Yep.
So I would entertain a motion that I'd like to hear from the public, but
I move that we accept jurisdiction on application 501-3.
We only accept it if it's considered complete reading of staff rules.
Yes,
We don't consider it complete, you cannot accept jurisdiction.
yeah, it's kind of the same.
And the staff is saying that it's not, they don't think it's complete until the secondary access is defense. We let it be online.
So that was kind of the older memo.
It's not reading off of.
Yeah, I don't think it's been updated, but I think the staff opinion at this point is that it could be considered complete because they did provide the waiver request.
Hmm.
So I think when you first wrote that memo, they hadn't provided the waiver request. So now that they've either like provide what's being asked for in the ordinance, or you provide a waiver request. So they do provide the request, whether or not you grant it with the question.
Or determine
Whether it's necessary, but I think there's no reason to call it incomplete for that reason.
So do I have a second?
I'll second.
All those in favor?
Aye.
Aye. All those opposed? All right, we have accepted jurisdiction on it. Moving forward,
Make some progress. So would you like me to just show what the subdivision is?
sure, why don't you run over a quick thing so the public here that is gonna get to weigh in has some idea of what you're talking about.
Be right out. I'm gonna go out and tick.
Oh, good.
Yeah. Yeah, we don't need
Wish him good.
fire usually works pretty good on this.
Can't reach the thing.
Oh.
I can't reach it.
All right. I'm already presented this to the Conservation Commission, so Sandy already.
Yeah.
So the property is located on Woodhill Hooksett Road. And it has 1,994, just a hair over feet of frontage, and it's 41.43 acres. There's an existing house located here, the barn. And near the center of the lot, and sheds, there's a shed and a couple cabins on the property as well. And what we're proposing to do is to subdivide the house on 2.379 acres, the house and barn. Create a second lot of 2.3 acres in this location here. And then there'd be 3 additional lots ranging, this one's 11.5 acres, 8.7 acres and 16.4 acres. There's a lot of conservation land surrounding this. There's one lot between the town conservation land and this property. But there is conservation land and looks at the town line and see this is Bo looks at town line. A lot of conservation land here too. So while we were looking at this, the owners thought it would be nice to create a common recreational easement. This will be on lot 1. This isn't a requirement of the town for this subdivision. This was to provide access to the 3 lots to get to the conservation. 4 of the 5 lots would have access to this common area, and this would then give them access to a lot of conservation land for walking and going out and enjoying nature. So
How big is that?
it's 5 point, just over 5 acres. So there would be a common easement, that each one of the lots would be granted to have access to be able to use it for recreational purposes.
Would there be an easement off of the road to get to that lot
So 3 of the lots have physical access to it
off the road?
for the public.
Yes.
No, it would only be for the subdivision. Okay, for the people in the subdivision. So the 4 of the 5 lots have physical access to it. To the east. So the Couple of interesting parts. There's a wetland system in here that's pretty significant. We didn't want to cross it. It's pretty wide. It's kind of steep going down in, steep coming out, so it would be a very big wetlands impact. So for the driveway, to prevent driveways crossing this in multiple locations, we had enough frontage. So this lot 2 has the required contiguous frontage, the 200 feet of contiguous frontage. But we also gave it 50 feet of frontage for a driveway so that it could get access to the building envelope without crossing the wetlands. So we avoided a wetlands impact that way. And then we also proposed a driveway easement across this lot 3 to avoid another wetland impact to get to the building envelope behind the wetland on this 11.5 acre lot. Building envelopes are beautiful. I walked them today, actually. Haven't been out on the property in a while, and I wanted to go take a look. They are big lots, 11.5 acres, 8.7. The building envelopes are separated, it's wooded in between. You wouldn't even know you had neighbors. It's the lots, these 3 lots obviously are small and close together. And in historical fields, so you would see them, but these 2 are very isolated. So by doing that, we created the 5 lots without any wetlands impacts. We do have a wetland buffer. At the meeting of the Conservation Commission, the question came up as to whether or not there was a stream in this wetland, because I know the way the regulations historically were interpreted by Bill Clubman again came up for this. If there's a scoured channel in this wetland, then it's a stream, and the buffer is 70.
Well, it's written into the regulations that way,
That way.
75 feet to stream.
To a stream, but if there's a stream and then there's a wetland beside the stream that's 100 feet wide. Bill interpreted it that the 75 feet is from the edge of the well, not the stream. Is that how?
I usually, whatever the farthest distance is, whether it's 50 foot on the wetland or 75 feet on the stream, so.
Well, with that interpretation, then it's correct the way it is.
But isn't that showing a 50-foot buffer?
It is. So what happens is, and the reason we originally didn't think it was a stream, because there is scouring, there's a culvert comes across the road, and there's scouring right coming out of the culvert, which is very typical. So what defines the difference between what defines a stream is a scoured channel, is what we settled in on. Okay, that's the difference between a forested wetland and a stream. There's a scoured channel in the wetland, so that is a stream. But you'll get that a lot at the outlet of a culvert, because the culvert focuses all the runoff into one spot and discharges it with velocity, and it's going to scour a channel. So there is a little scoured channel at the outlet of the culvert. Then there's another culvert, just a few, about 50 feet down, there's another culvert. And right at that culvert, the channel goes away, disappears. There's no channel. It's just a forested wetland. So we thought, okay, it isn't really a stream because it's just the culvert. So I walked in today, but that area without a scoured channel only lasts for about 75 feet. And then in this bigger wetland system, in the very middle of it, there's an 18-inch wide scoured channel that runs the rest of the way through the wetland. So there is a stream inside the wetland, but it's more than 25 feet from the edge of the wetland. The reason why we didn't know it was there is because you have to go out into the wetland to see it, because the wetland is 125 feet wide. When you're mapping the edge of it, this 18-inch scoured channel in the middle of this wetland system, you can't really see it as you walk out there. So
I just got a question on your driveway accesses that you're talking about in here. So we have one on the narrow, skinny strip, which is which is lot 2. Driveway access would come in that skinny channel, and basically the wetland is the rest of its frontage on the other side.
right.
So-
This is a
Lot 3 will have a driveway access.
Yep.
And then there'll also be a driveway access for lot 4 that comes off lot 3.
Yeah, it cuts off the corner of lot
Cut, so,
3.
and how much frontage is there just where those 3 driveways hit? About, like, just so, like,
250 feet.
for the 3 driveways.
Yeah, I mean, we could make, the one driveway easement could be a common driveway, might make sense to do that. They would split almost immediately, but that would only make 2 curb cuts in 250 feet, which is not excessive. Board felt it was a lot to have 3. Slight distance right at that particular spot's pretty good. But yeah, that's something to think about. This little strip is 50 feet wide. But it's wide enough to put a road in, but it's only a little driveway, so it's.
Yeah.
So,
Long straight driveway.
yeah, it's what happens with a 9-acre lot. Yeah. Yeah. So that's a proposal. We did ask for 3 waivers originally. And the board will have to decide about the 4th. We did ask for the existing house has overhead utilities. It's been completely remodeled. So one of the waivers is to allow that one house,
The existing.
existing overhead utilities to stay overhead. All the new construction would have underground. An erosion control plan. So one of the other things, we weren't proposing any development, so we were going to ask for a waiver for the erosion control plan. The Conservation Commission did ask, and this is taking a look at the driveways today. They asked for a profile view of the driveways, especially the one that's closest to the wetland. And we agreed to do that. And when we do that, and I took a look at it today, right today, there's no decent ditch line alongside the travelway on Wood Hillock on this side of the travelway. So we'll probably end up having to create one. So we'll probably do some erosion control on that plan. So I'm not sure if that still applies. So the only construction will be the driveway, and we're going to do a profile of the driveway to confirm our impacts and everything. So we will probably, because we're so close to the wetland, we should definitely show erosion control in there. So that one we may take off when we finish that profile. The 6.03W, the operational brief that's requested. It's 5 lots fronting, 41 acres with 1,000, almost 1,100 feet of frontage. So we didn't really, that's more of a very complex subdivision, I think is what that was looking for. So we're asking for a waiver to not provide that. And if the board would like to go on a site walk, it seems maybe premature, premature,
Yeah.
premature for, but you have to answer any questions?
Yeah, let's go back to that 5 acres. You called it conservation land,
Sure. But common recreations,
and you're gonna put an easement on it.
correct. So it'll be,
Who would own the underlying land?
it's part of lot 1.
Okay, so they would own the whole,
They would
5
own the
acres.
Underlying fee,
yeah,
and then the other 4 lots would have an easement over it. for
Okay.
for recreational access limited
Okay.
to enjoying the
okay,
walking.
okay.
Maybe snowmobiling, but whatever the abutting recreational land restrictions are is probably where we would end up. So if the conservation land and hooks it allowed snowmobiling, say, it'd probably allow snowmobiling on this conservation easement. If it didn't, and it was only for walking trails, then this will be just walking trails, because there's no point in allowing snowmobiles if you can't go anywhere. You're just doing a loop. It's not much point to it.
Also that,
And the wood road that goes across there, what is,
So this was an old farmland. This was farmed. There's still large fields on it, but there's woods roads all through this. That's a major one that runs through, and it keeps going all the way and goes into the town forest and connects to other trails out there. But there's trails all over this piece of property. That one's just a major one. It's been there for a really long time.
that'll be the path in on the sidewalk.
Yeah, it makes it a little easier.
The board got any other questions before I open this to the
Well,
public?
I guess I think that we need to know a little more in terms of the recreational easement. First of all, a good part of it's wetland. And then secondly, more information on, you know, the adjacent land and what's really allowed, because it's kind of you know, unless you can really demonstrate that there's a reason to connect that with the other land.
Okay, we'll take a look and see what how the conservation land works and hooks it, see if it's. You know, if it's restricted to access, then yeah, that begins to bring into question whether or not that 5 acres is worth.
I mean, for these lots, I mean, with the exception of lot 3, if they went straight back, they would all have.
Yeah, wouldn't make any. But if it, yeah, that's all we would do. If we got, if it was decided that this didn't make sense, then we would just extend all the lot lines and lot 2 is 16.4 acres now. So it'd take 2.5 and add it to 4, so that would become 13 or 14 acres. That
Yeah.
would become 10. And that would
You just continue the line straight back.
Yeah.
Anybody else on the board got any questions? All right, open to the public. So seeing none, I'll open to the public. Just please state your name and address and. Anybody?
Richard Thomas, 181 Woodhill Hooksett, across the street.
Okay.
First of all, I'd like to object that the application was accepted in place. And also town officers did note objections in the public record to having this complete. I saw it on the website, so we couldn't see it. So I'm a little confused about these driveways that are all gonna be pointing their headlights into my house. How is that? That seems pretty unconventional, and I don't understand how driveways crossing lot lines conforms with the zoning requirement for a 15-foot driveway setback. So if you're crossing a lot line, how can you be agreeing with the setback? And there is scouring upstream of the culvert as well as downstream. So that makes a 75-foot setback, which pushes that driveway.
Okay. So where they're showing is basically is pointing right out your houses. Okay. Anything else, Lisa? You look like you want to say something. Are you done? That's,
I had some other thoughts, but I didn't bring it with me tonight because I didn't think we were gonna get this.
okay. I have a pretty good idea. There'll be a, yes.
I'm Joel Joliker. I'm 182 Wood Hill, Hooksett Road. I knows who I am. I'm a neighbor that has restrictions on the property. And
What type of restrictions?
A lawyer tonight to represent me. I don't know why he's not here. But I ask for continuance. I also object for the decision you guys made to continue the meeting. I also have a few other things. Mr. Robert here, Stratus, the well-known real estate agent in Bedford. He's a well-known builder, also built multiple houses. So that being said, when he bought this piece of property, he should have known the restrictions. He should have done his due diligence. He wasn't a coward. He knew what he was doing. Thinking that he can buy out me, that he tried to offer him all kinds of things.
and try to get those restrictions off my property.
What's restrictions on your property? What's the?
There's no more subdivision allowed. I built my house,
Okay, yeah,
So
I built my house according to those restrictions. Knowing that those.
which, yeah, I'm just trying to figure out which property.
Yeah, I'm
for
not
them,
following.
so, and that was the, which year was that one? The 2004, 2001,
2000.
He subdivided.
So
it.
four, it was split into two lots. One became this gentleman's and one became the property in question.
Okay.
Right, and neither lot was to be further subdivided.
And I got here late, so I didn't get her name and who she was, so can you please tell me?
Attorney Pansy Alpha.
What about her?
Yep.
Okay. Well, that's all I have to say. I wish we can continue this and with my professional, with counsel, with lawyer.
Okay, because you had
The lawyer.
counsel was supposed to be here tonight.
Yes, I don't know for some reason he's not here. But he should have known, he should have done his due diligence. I don't know why, how can you take a restriction off a property? Those are my rights. How can you do that? How can you allow that? There's restrictions on the deed, how it's stamped, that everybody signed off on it. It's clear on the plot plan, it's black and white. I'm a contractor, I'm an estimator by trade. I read drawings all day long for big buildings in Boston. And every detail in those drawings, I read them before I sign off on anything, before I send off any estimates. And if I have any questions, I do an RFI out to the architects. He's a professional builder, he's a professional architect, real estate agent, he should have known better. This is not over. I have my rights and there should be no subdivision allowed behind me or on that property. There's restrictions, it's stamped on the drawings. That's it, that's all there is to it. I don't know why we're continuing, why you gave him permission to continue. You're just avoiding those restrictions. That's unlawful. A lawyer, but
I'm not one either.
my first language is French, and I can take 3 languages. So I can speak for myself.
So
I can read.
the biggest reason why I wanted to accept jurisdiction on this tonight was so I could hear from the public. So that's it. We haven't approved anything, but that was,
I don't know if my lawyer contacted the town lawyer. I was out of town. I came back yesterday. Assuming he was gonna be here. I had no idea. I had no emails. I assumed he was gonna be here.
okay.
Of course, I also object to, building more houses on the road that's already overbuilt.
Anybody else in the public have comments? Okay, seeing none, I'm gonna close the public hearing.
I have a question.
Okay,
If we were to approve the subdivision contingent on you resolving the legal issue in question, how do we enforce that? If they build.
They wouldn't be able to build until
They wouldn't get.
until there was.
It could be an administrative condition. You would need a letter from a court saying that restriction is not valid.
Yeah, to issue a building permit.
so, I mean, with
Sign the Mylar.
hearing the testimony that I just heard, the condition of not being subdividable, part of that was from the landowner that sold it. I mean, I'm just trying to, so I have, I got 10 acres of land and I want to, subdivide 20 acres land. And I want to subdivide it, but I don't want to, I only want one house next to me. And I put, in those plans and doing that it can't be subdivided and it gets agreed to. I mean, I don't think, and then who, the person that agreed to it, and bought it the first time sells it. Now the next person says, well, that was unconstitutional to restrict the land rights, but I guess I'm getting lost and I'm not a lawyer. I'm not, but that's kind of what I've heard out of this. Which brings me back to, they need to get that part
I'm with Don.
figured out.
Putting myself in a situation of both sides. If I buy a piece of land. And either I'm ignorant of the rules or know the rules. And then turn around and I bought it from a neighbor who did this because they didn't want to subdivide it, then try to subdivide it. That doesn't seem right to me. I feel that they could, obviously they can go to the courts and they should go to the courts. But and I've said this from the beginning, I just think they should deal with that first. And then we can come back and deal with the road issue, the fact that previous planning boards seem to ignore. Or maybe didn't ignore because the road issue, certain things being subdivided after the fact. I also don't think just because the planning board before us ignored rules means that we should be continue. You have to, at some point, you have to do what's right, regardless of whether something was doing wrong before. And I've said, not shy about it from the beginning, I don't think I'm voting tonight, so I can speak without actually having to put my name to it. But I just think that putting myself in the position of the other people on the road and the person who bought it, they should deal with this in the courts, get that sorted, come back, and then we'll deal with the road issue and subdivision issue.
Can I say one thing as you,
I
or
agree.
is that over with?
No, it's open.
Well, I did,
You-
but yeah, so you're the landowner. Yeah.
One thing.
Name.
My name is Robert Starris,
Could you spell the last name for you, Robert?
STARACE,
And address?
10 Dorothy's Way, Bedford, New Hampshire.
I would say that you're part of the applicant, you're the landowner.
So what I would like to say is everybody seems to be hearing no more subdivision. It doesn't say no more subdivision. It says no more subdivision without a secondary access. And what I think the point we're trying to get across is this class 6 road that was not maintained is the secondary access. It doesn't say anything on the plan, no more subdivision. It just says it needs a secondary access. But that rule was on roads in town that was proposed in 1979 for new roads, not the old roads. So it was put on this plan in error, in my opinion. Joel Joliker did sign that he did not want any more subdivision on his piece of property. But if you go back in the minutes, Danny Day clearly objected to that restriction. So if you look at it as no more subdivision unless there's a secondary access, we already have a secondary access and it's the class 6 road. And let me finish. When Joel was asked that question back in 2004, he said the same thing that I'm saying right now. Oh, there's a road, it goes right through. You know, he wanted it to work for him then, but all of a sudden now it's not good enough. He got his lot, so now it's not good enough for the rest of us.
Just a question, in 2004, when that was put in, what was the status of the road? Was it already? Was it already not being, was it already considered by the town not to be a thoroughfare?
It was not being made.
It's
Not maintained,
Then
which means it's not a
when you bought the
Yes,
land
when there's-
before,
2 feet of snow.
it sounds like you didn't have a secondary access, according to the status, the state of the road.
What I'm saying.
I don't know, I'm just, that seems.
What I'm saying here is when Mr. Joliker wanted his subdivision. One lot that he lives in that was 5 acres that was taken off this piece. He was asked by the board, it's clear in the minutes. Where is your second access? Or, because Bill Clubbin was considering this not a grandfathered road. And his answer was, well, there is this through street that is a class 6 road. Or however he worded it, it's in the minutes, you can read it. And it was clear that everybody else on that street that got subdivisions after the 2004 probably said the same thing. The board interpreted it the same way and granted the subdivisions, but yet this little note,
Why would you put a note in? Demanding secondary access if there was already secondary access?
that's the error. That's what I'm saying. And I would like to look at every other, I would like to look at every other subdivision that happened. Is that same note on their on their lots? Is it?
So I'm sorry, just to clarify that
I
question,
can tell you why.
you're saying
Every other subdivided lot.
Since then on this road.
2004,
on this road,
or since 1979, when,
on this road,
on this road,
how many subdivisions have there been on this road since 2004?
a lot.
9. Okay. Closer to the road to Bobog,
No, both
both ways.
Some farther away at the end. That's what she was saying.
And that is 9 on this end.
Allen would not be, I don't understand why that would be relevant.
Yeah, that's the other end of Woodhill. So
Right.
The middle of Woodhill X Road isn't maintained. Just
Right.
dead ends.
And it was the town that let it lapse. So if the town decides that it's in the public interest to not maintain a road, does that mean you become a dead end road? No, it's still a public way. I don't care if there's water there or not. It's still a public way.
I'm not persuaded by that argument.
I'm just saying, I'm not saying it's just.
It's not egress.
Yeah, I'm just not persuaded by the argument that the town, once a road is in any way, shape or form, that is a road for all time and the town can do nothing about that without it being an unconstitutional taking. I'm just not persuaded. You may be able to persuade a court to that.
Until the town discontinues it, it is a public way.
Yeah, again, I'm
That's the
not
law.
persuaded by that.
Okay, well, it's the law.
And it is, I mean, it's,
That's at your own risk. Signed up.
our ordinance, I'm pretty sure it talks about egress. And
Mhm.
They put big steel gates also down there.
Yeah, I'm not saying it's.
okay, unless we have a fire
Right.
in the winter time, when there would be.
When we did subdivision in.
So anyways, I guess, I mean, we've heard the argument, and I understand the argument. You know,
Can I
but
just say one more thing?
sure,
Sorry to interrupt. When we did subdivision in Loudon, in the storm of 2008, you know, those big Mother's Day floods, we lost a whole road. And they actually went in because they couldn't get the road fixed. It was literally 70 feet wide, 40 feet deep. They went in and they revived an old class 6 road. Very much in the shape that this is in, and considered it, that's what they used for months until this road could be repaired. Relevance of that is,
and if the front of, you know, Woodhill, whatever on Bow Bog, you know, gets taken out for, you know. Whatever reason, I mean, that's something that. Would probably get done to get back to that road, is to get it so it is, you know, a passable egress, you know, so as that way in, but that's, I mean, I think our. You know, what they put in, you know, on the fact of safety and egress is that, you know, during that storm event, when that tree is down. You know, and I guess it's kind of arbitrary, you know, it's okay if 12 people are trapped or 12 families, you know, but it's not if it's 13, you know, is what, you know, which. You know, here that, but, you know, that is what we're putting in. I mean, this road already has a lot, and it is about egress, you know, is as I understand that. And that's why some places is. You know, we put a 2-lane road, but the idea is that you keep so. Trees can't fall in, blocked away, whatever, and it's at the time. If the whole thing is washed out and can't be done, well, obviously, you're gonna, like in Loudon, they made a new road going into it. I think that's a different. Case than what, you know, we're talking here, and not a, you know, a. Major storm of how you fix it afterwards.
I do think just because there was testimony that the 12, and you just mentioned arbitrary, I don't think that's true. I think what the attorney referenced, a distance makes sense, right? But that's not the only logical way to regulate that. Like limiting the number of houses limits the probability of an issue. If there's 1,000 houses, the probability of a fire is higher than if it's 10. That's
Yeah.
right. So it's not irrelevant or an arbitrary number necessarily. So I just don't want the board to lose sight of that. Because it, you know.
Yeah.
There was an argument to the contrary.
And I agree. You know, my point is that,
Yeah.
you know, there is a number, you know, that was, you know, this board wasn't the one that set that, and however, and part of that comes from our safety, our fire department, and, you know, and that's why was their concerns in this.
I mean, I largely agree with Kip. I find the way you've phrased the detail of the language does matter. Right, so that's why the road does matter. I think it's not a permanent restriction on subdivision. It's a restriction on subdivision until there's a secondary access. To me, those are very different things. So Kip, your point about, well, if you buy a house and you're thinking that there can't be any subdivision ever versus until that road is finished, that's totally different equation. You know, until a road is finished is like that land could be developed and will someday. Not ever means I'm here in the quiet and it won't be disturbed, but those are fundamentally different positions. So I think that's persuasive to me, but. Yeah, I don't, the road thing, I just concerns me. I don't. To me, I don't see how it's a road.
So could the applicant, is a little out there, and I don't know. And I don't know how much it would take, but could the applicant propose to turn it into the town road as part of their application?
Class 5.
Yeah.
Return it.
And that would,
Yeah, I don't.
that would fix the problem with the 30 houses on there, and
Probably
I don't know how long the road is, I don't
Yeah, I think
know.
it's pretty far.
I don't know what it would
I think
take.
it's pretty far, and I think it's a pretty major wetland. And I think I had brought that up again. Well, yeah, if it was a through road again, it would, you know, definitely change things. You know, I guess it still kind of raises the question of when it was subdivided in that, you know, according to testimony here, when it was subdivided, that it was, you know, part of that was put in because the person subdividing, so it can't be subdivided further, or was that put in by the planning board because of egress?
If that, I mean,
It says access or egress.
I mean, I'm just assuming for a moment that
Tim, do you have that?
that's true. I mean, it sounds like they were like, hey, let us subdivide this. And the board was like, all right, but we're not, no more because until there's another road. That sounds like something the board would do. One lot, one house, okay. No more, the roads are finished or not.
But then 8 more after that.
That's my problem.
Yeah, that's the problem.
That's my problem.
And there were plenty.
You're allowed to continue to build on that road with that class 6 section being there.
Yeah.
That's the problem for me.
And I mean, this board could, you know, deny something or pass something, and the next board, it changes.
The not to cook fork
Particular regulation.
surrounds that road, that 6 road, it's like a mile.
Yeah.
And
So
Is it 9 subdivisions or 9 houses?
9 subdivisions.
It was subdivided 9 times?
It was only 2 after that stated,
one
Right.
and I objected to both.
One thing I would be interested in looking at is whether the secondary access provision was waived for those 9 subdivisions, or if it was determined to not apply. I think that would be kind of interesting to look
That's a
at.
good
Yeah.
question.
Yeah, because we really, and I wasn't here for the legal opinion, but I mean, we definitely needs, I don't know if the board can really decide whether that regulation applies or not. That feels like we should ask town council that question if we haven't.
Well, but we've already approved other subdivisions on the road. That's what's bothering.
No, I understand that, but to Kip's point, I think at some point you have to do the right thing.
Exactly.
Assuming it may or may not have been wrong. I think what you're saying about researching was for nine times where we like, oh, that doesn't apply.
Right.
Or 9 times did we waive it? I think that matters. And then also, what does town council think about the legal interpretation of a class 6 road?
The limit, the 12 limit,
Yeah,
you know, is it just for new roads? Is it, you know, it is some great questions for,
Well, the other thing is if you waive something too many times, then you need to look at your,
Right.
your
The base.
ordinance and then say, is that,
I don't, what I don't understand is, you know, if we've granted all of these apparently 9 waivers of that regulation, why didn't we take a look at the regulations, say, well, we need to clarify this and say what do these 12 house limitation apply to? Is it just new developments or does it apply to existing? Because right now it doesn't say, there's no differentiation between
At this
a
point,
new division.
we don't know what we don't know.
I mean, and to that, I think it's something that the planning board should get clarified, and even if it's gotta, you know, be a change, you know, whatever, but it's definitely something that should be on the to-do list of clarifying that.
To me, I'm. In terms of interpreting the regulation, it seems like a new versus existing road is. If we meant new, we would have just said new. It says road, right? So I think a court would be very likely to rule that it was just, you said road.
Yeah,
So I
no,
don't think that particular issue. So the question to me is this a road? Or not? The class 6 piece.
Well, it's a class 6, but I don't think a reasonable person
right?
would think that it is passable.
So
I mean,
that's where I seem to be, right? So I don't, you know, it's not the newness of the
Well, it's not even-
grandfathering to me that's an issue.
It's egress, right? It's,
it's not
Yeah.
it's not a passable road. I mean, you probably know that more than I do.
It's passable. I know, it's unpassable. The snowmobile trails go through there the winter.
Fire
But
truck.
I mean, if you got for a fire truck or for a four-wheel,
There is absolutely impossible for a fire truck to go through there. Impossible.
or a car even, yeah, car, anything
4-wheel drive, Jeep, pickup truck to be able to go through that road.
high,
And it's getting, yes, because there's a stream
yeah,
and it goes like this.
and there's boulders,
Boulders, rocks.
yeah, so it is not passable. But that's
It would cost millions of dollars to make a road down there. Millions.
gonna be,
That cuts right through the swamp also. You'd have a bridge.
fun ones. So
I don't know, so
we keep this raising more questions.
a lot of questions. I don't know if it makes sense to take the time tonight to go into non-public session again and re-review, because believe the attorney got into a little bit of the areas you've been discussing, and I don't know if that'll help. I don't think he's gonna answer any of your questions for certain.
well, you think we wouldn't come to a decision tonight?
I wouldn't expect.
No,
you to.
because we need additional information from the abutters.
So I think, I think a little bit, we need to kind of get a list of our questions and.
Yeah.
And so we can get answers to them and. Continue to,
Yeah, the other thing I'll mention, I guess, is that a previous planning board chair did come to me. He may be willing to share some insight as to what was the intentions of the board at the time as he remembers it. I don't know if he'd be willing to come to a meeting or share some written comments, but that might be something you want to request.
that would be good.
Yeah.
I have one more question. Can I speak
Sure.
before? I would like to have the restriction. Have a judge decide on it in court. Before any decisions is made in the
Well,
town.
that's not. Like, we don't,
So you're overseeing the decision. The decision, I believe, should be made in court first to remove my restriction. And then the town go from there. Why are we gaining it?
Okay. yeah, so with that, just. That's your property, which isn't part of this, I'm happy to hear.
Restrictions are on my deed. It is part of my property.
No. This is what they're doing isn't your property.
Yeah, but they're trying to
Needs to be.
take away my restriction, my rights. That should be resolved in court. Shouldn't be resolved here in front of the board. Should be resolved in court of law. I think something.
It's gonna have to be, so
My lawyer with me, but.
Okay.
Lawyer, but
we're not gonna, so
should, what happened?
we're not gonna make a decision tonight. There's not gonna be a decision on merits of the application. So don't worry. Yeah, I understand, but don't worry. There was going to be my best judgment a day in court here. And what we'll ultimately do, maybe before that, maybe after, I'm not sure how quickly you'll be getting into the court, but it won't have a bearing on what the court does. So I don't think you'll have a chance to come back with your lawyer. Yep, I think that's fine. But we're not gonna make a decision anyway, so there'll be more opportunity.
One more question to Mr. Stratus. Why don't you sell your property, build a nice house?
Yeah.
Recover the money?
Yeah, pass that outside.
That's outside of this scope.
Well, I just-
You can do that, afterwards.
Yeah.
Not on our time. The applicant has a,
I don't want to hide the ball here. But if we are told to go to court first, it's going to involve everybody here. The town will have to be named because they have a stake in the decision. I don't want to hide the ball that we can go do that and fix it without other people being involved. I just want to be clear about that. That's why we hoped to resolve it here, at least to some extent, so that everybody's acquainted. If parties agree, they don't have to get involved in as much. But I'm not saying I'm gonna sue the town, that's not my point. But when you have a situation like that and you have to file a quiet title case to take a title cloud off of land, you have to name all interested parties. The town wouldn't necessarily be one, we couldn't avoid that. And they will ask, did we try to work it out at the local level? They don't want us to go to the court if we can avoid it. So just to be
So-
clear.
this for me to clarify too, your property, you bought this after it was subdivision, these restrictions are on it, or you owned it when it got subdivided?
No, I subdivided.
You subdivided this off.
Mr. Bernie subdivided for me. 5 acres off of Danny.
The days subdivided the property.
And when there's a 12.
Joel purchased the lot after it was. But
Okay.
just like I told the board earlier, everybody that proposed to subdivide this, the days, they went to the days and said, we'll bring your property through to development and buy the lots from you when it's approved. Because the days didn't have the money. Joel did that, the developer in 1998 did that. So Joel paid for the survey work and the meeting and the plans. But the days were the owners of the property at the.
Because you got the 9 and 12 lot subdivision, they allowed this lot to be subdivided
Okay.
because they didn't want 12 lots subdivided. So they gave her the lot. That was it, the stamp was done and I mean, it was written.
Okay. So I think we've heard enough, that's right. I guess we gotta have, a little bit of our list of questions here to continue and,
Yeah, and then just the other kind of housekeeping item is that so far we've only addressed the subdivision application. And so I don't know if you want to accept the CUP application as complete and open a public hearing for that as well, just so it keeps the chain of notification rolling. Because if you don't, we have to
I did, yes, I closed the public hearing. Yeah, show it.
Well, I don't want to have to re-notify everyone. Keep
So you just want, just so we have jurisdiction and using them both.
rolling together,
together.
I think that would be helpful, because if you don't address it this evening, you have to re-notify everyone for the next meeting. But if you open it, have the public hearing, announce the continued date, then we don't have to send out new notifications.
Okay,
And the condition that we only take comment on the conditional use permit and not
Yeah.
the first public comment.
Exactly, yeah.
who wants to make a motion?
All right, I move that we accept the wetland conditional use permit as Do we say that as complete? Yeah, or accept jurisdiction.
Yeah,
And it's
section.
application number 404-23.
Thank you.
I got a second?
Second.
All,
Kara, who was that?
that was Michael. All in favor?
Aye.
Aye, opposed? There we go. Now have jurisdiction of application 404-23. Does the board have any comment on the wetland CUP?
Well, we talked about some of it.
We have,
earlier.
we have already talked about some of it.
I have work to do. So I know what I need. Get completed, more complete information.
Okay. Yeah, I mean, with the, you know, kind of the driveway thing seems a little weird.
You know,
I mean-
yeah, the other thing is, while it's not only the wetland, if you look at the wildlife action plan, that whole large lot is a tier 1 habitat. So I guess I, you know, kind of have concerns about the extent of development on that lot and what, you know, I'm not sure what's there, but in terms of minimizing impacts.
Yeah, we'll do it. I mean, it is 11.5 acres, one house, but we'll look at it and see what we can do to make sure that we do. Try to preserve the areas. Makes sense.
Okay. With that, I'm gonna open the public hearing to the wetlands CUP. People have comments on that.
Thomas, 181 Wood Hill, Road. Actually, I wrote an email earlier with my comments on this, already. To just correct the statement the attorney made, this is a scenic road for the whole length. And that should not be considered. Excuse me,
If you could find me the vote, that would be great. I
in the
would,
master plan.
that's not, I knew it. Boy, the clerk may not find it. So we should know that. If that was from.
Okay.
In the master plan for 20 years or more.
There should be a
I mean,
positive vote.
so anyways, back
On the scenic road.
to the CUP. And earlier you had mentioned that there was some more scouring, whatever, which you're gonna make sure that.
Culvert is closed down.
The national,
When you go on the sidewalk.
the National Wetland Inventory shows that as a stream the whole way. So,
Okay. Anybody else have any comment about the conditional use permit?
You should protect the salamanders.
Does anybody did research on the turtles, the wood turtles over there?
I'm sure Sandy did.
Yes.
well,
I think
that's
easier later.
That-
why we do a site walk, but yeah, with the Natural Heritage Bureau.
The Hooksett Town Water also has the town of Hooksett been notified about this project. That dumps into the town water.
Did we ever do
You
the
haven't,
regional impact?
haven't yet, so.
Yeah,
That is. Should.
Yeah.
Yep.
Yeah. Yeah.
3 houses are regional impact.
Well, just because it's adjacent, it's not, doesn't have to be a big impact. But here they're also proposing the conservation land that's adjacent to Hooksets and trying to tie in.
So if the board does determine that it's a regional impact, then those adjacent communities would be notified and the regional planning commission would weigh in as well.
Just so the board knows, we, as a general rule, whenever, because the statute actually specifically says if it's on a town line. It's actually part of the statute. So we always, when that's the case, we notify the budding community and the Central Regional Planning Commission, which are the 2 requirements for, so we. you still need to make the determination, but we've met the requirements ahead of time either way.
Okay.
We realize that the way the statute is written, pretty much if it's on a town line, it's regional. That's the way I read it, but you guys get to decide. I don't.
Okay. Anything else from the public? Not seeing any, I will close the public hearing. But now that we're working these kind of together. We gotta,
Do you want something on the regional impact or do we want to wait?
Normally I would say yes, because it triggers the notification time period, but if he's already done it, it doesn't matter,
Yeah.
so. Whatever
Should
way,
we, I guess we probably need
I mean, if,
information that they were notified.
yeah, would put it,
Yeah.
document that back files.
Should we reach out to them to see if they have any comments on it, or would they only
believe
submit
that's-
comments if they? Comments?
Yeah, I think that's what they're noting.
I mean, so if we consider that regional impact,
Mhm.
I mean, he said he's already done the work, so.
So we'd ask to verify that. I don't think.
Yeah,
that's- yeah.
well, we could say, we could make a decision that it is. The work may have been done already, but we still,
Yeah.
You have to decide
You
either
should
way.
make a decision one way or the other.
yeah,
Yeah.
yeah. I'll move that we consider this a project of regional impact.
Second.
All those in favor?
Aye.
Opposed?
So if you can send me the,
Yeah, I'll coordinate with you.
thank you.
Okay. We got some questions to
Get answered.
Yeah,
answer to,
So we need to continue this. to-
Yeah.
and yeah, so we're gonna need to continue this.
yeah, do you like to jot down a few more specific questions if I can? I know we have some. Like this question.
Yeah, there was a lot covered there, so.
I don't know if I can remember from all of this, but we can listen to the video or watch.
I
the
don't
video.
know that they all have clear answers.
I mean, from the board, do we
Are
have,
there specific questions you want me to ask town council?
I mean, the big one for me is the regulation that limits lots to 12 acres with a single
Or
access.
12 lots.
12 lots. Is that intended to be for new subdivisions? It doesn't apply to existing roads and should be change our ordinance.
I guess, you know, with that is, what did we do on the other subdivisions on that road? What did,
Yeah, was
Path
there,
forward too.
yeah, I guess, was the documentation available in terms of whether there was a waiver for the previous decisions? Some of which I was at.
Okay, yeah, I can definitely do the research on
Yeah.
the other subdivisions that were done since that time.
Well, scenic road was a question.
And I can look into that. I don't know how much it applies.
I don't know
It was
how much
It was
really
raised as
impacted.
a question.
Yeah.
I mean, they deserve an answer.
It relates to the why did they keep subdividing question, but I'd love to know from a legal perspective, does buying property with that note change the rules for that property and not other people on that road?
Can you rephrase that for me?
So what I'm saying is, if I'd owned that property since before the rule was changed, and then I was allowed to subdivide. This goes back to why were they able to subdivide it?
Yeah.
Does it change from a legal perspective, since if I bought the land after the rule was changed and I knew that stipulation was on my property? Does that change the rule for me and not someone else who did not buy their land knowing that stipulation?
You're saying pre and post 1979 when the,
So. The definition of. Road too, right?
When the road, yeah,
Um,
did you buy your land knowing that that was a class 6 road?
well. With or without secondary, second egress. No. New road, old road,
Basically, we'll learn all about roads.
I mean, our fire chief lives on a class 6 road.
He lives on the other end.
Do we want to ask if a class 6 road is a town road? That's,
Yes.
Well, it is a town road,
well, it is, but is it, but does
but it's,
that count as does it count as secondary egress? It seems like the answer is no, but
Maintained, so,
If it's not passable,
right. It's not
then
made.
it doesn't, then it can't be secondary.
So
I
there's,
mean, that's the way that I look at it, but do we want
so there's.
to ask the
a
question?
reasonable person would think.
For class 6 roads, there is a designation or a route that the town could take to designate it as emergency access lanes.
Yes,
And that means allows the town to maintain it just enough to make an emergency access lane, and it appears that that is not the case here because.
right.
So I think without that, then it's not.
where we have allowed to build on class 6 road, they have to maintain it.
Yes.
You know, the town, it's not town maintained,
And they
but
have,
somebody is, they have to, it has
and they
to.
have to sign a waiver saying
And
that
that's
they're.
what has to prove it.
What selectmen has to approve it, they have to sign a waiver saying that we recognize that emergency services might not reach us.
And, yeah, I think that's,
So we need to set a.
we need to continue.
Yes.
Do we actually just real quick, do we want to take a look at that? Before we make the final list?
I do.
Which letter?
The one
Email
from our
them all.
attorney.
Oh.
And I do have, I have a small, he has a small update to it, but.
Okay,
Do we need to
can we,
non-public? I moved to go non-public. They're from town council.
Second.
Well. Can we delay that till the end because? we're
But do we
pretty-
want to do the continuance and then go into non-public?
yeah, I would kind of like to,
Well, okay, I'll make a, can I do a joint motion for both applications? To continue them.
can you vote?
Yeah, there's the open motion you guys just. That is still.
We have to kill that one. All right. Vote on it.
Well, if we're just gonna review it to see if there are any more questions. That may, well, that we may have
Well, it's
answers
fresh.
for. Can't we delay non-public to the end?
That's right.
Yes, that's what we'd like to
We're
do.
saying.
Oh, okay, I'm sorry.
So, but right now we have a motion and a second to go into non-public.
Vote against,
Yeah,
just so we can kill it and then.
yeah.
Okay, okay.
So
It's so David.
David made a motion to go into non-public.
Seconded it.
I seconded it.
Yes,
It has to be.
Roll call vote.
yes.
Oh, God.
What have you done?
So
That's how-
Mike, how do you vote? If you vote,
If you vote
So-
no,
Not to go into non-public.
so you're voting no.
No.
Adam,
No.
how do you, David,
No.
Michael?
No.
Sandy?
No.
And myself, no.
Okay,
So we're not going into non-public. So what I think we should, is if we can
Set a-
continue this. Get through our other business. Go into non-public before we go home tonight and
Got it.
discuss it. Well, it's fresher in our head and
I'll
let
make,
everybody else be able to.
I will make a motion to continue applications 50123. And 40423
That would be
to next meeting.
that
The June 15th,
22nd.
22nd.
22nd, that's the fourth
The fourth?
Monday,
Oh, maybe it's
the
not.
fourth Thursday, the third Thursday is the 15th.
All right, maybe it is the 15th.
all
Let
right.
me just double check. Let me just double check. this one. Yeah. Normally, it might have been Tuesday or
that
something.
doesn't make sense.
20th is ZBA.
Tuesday.
Yeah,
So do we want to vote? All those in favor?
but we're trying to get a date.
I'm
Okay, well,
I'll be there and just.
it's the 15th is the third Thursday.
Right.
So it should be.
Just make sure.
Works better for me.
ZBA.
It's the 15th.
It is the 15th.
Yeah, that's the third Thursday.
Yeah.
First.
So the 15th, that's the motion. So we're gonna have a meeting one way.
Is that okay?
I think so. I'm just
Yeah.
trying to open it here.
We hear a second on that?
Okay, second.
Okay,
I'm sorry. Can I get that? David and then Michael?
Yep.
yes. All those in favor?
I,
Opposed? There we go.
To continue.
We'll see you on June 15th.
thank you.
Thank you.
Okay. Moving on.
We just jumped through,
Oh.
I heard the question about what is non-public.
Yeah.
It's, we go into non-public session. Not in front of the public to
Correct.
discuss what the lawyer. The town lawyer
Ex-
advice, so it's like attorney-client privilege.
Yeah.
They said something about this application, we don't even know, but no decisions are made and
Non-public.
non-public.
Right, that's what I.
Yeah, no decisions are made.
Decisions.
It's just, it's what we discussed, what the lawyer told us.
I don't have compliments or.
Yeah, no decision.
Get your counsel here on the 15th.
He's gonna get his ass over here.
Yeah,
It's not gonna enjoy this
he
phone.
should pay you for tonight.
Thank you very much, gentlemen.
Okay, we ready to move on? At 10:09. Number 4, public hearing to revise and amend the August 18th, 2022 notice of decision approving the application for site plan approval filed by Amberbo Associates LLC and the Sarah Santee Estate related to property located at 75 Dow Road. Block 5, lot 42 and lot 47 and lot 48. Located off Baker Road. The planning board's August 18th, 2022 notice decision. And the associated meeting minutes from the planning board of August 18th meeting. Reflected that the planning board's decision related only to the phase 1 proposed project when the planning board's previously intended for its decision to approve the entire property, the entirety of the proposed project. The purpose of this hearing, therefore, is to correct the previous inaccurate decision. So a lawyer wrote that one.
The attorney wrote that.
Okay.
Yeah, we had
I think
a discussion about, again, Tim Bernier, Tia Bernier, and Andy Perlman, attorney for Peter. Peter decided that he talked enough to you guys last month, so he wasn't gonna come again. That's like,
Good evening. I'm Andy Perlman, attorney with Perdier and Perlman. Perlman is Perlman. Thank you.
Yeah, so this is just to the way the original condition was. The board voted to approve the project with conditions based on phases. And then the minutes and the decision came out that only phase 1 was approved. We talked about it and everyone agreed, and then you got advice from council on how to correct that, and that's what we're here to do tonight. So that's the most important thing to us because it's really causing issues with the project, so we really need to get that resolved so that all 3 phases are approved, however, conditionally. In addition to that, we did talk with Carrie about some minor modifications we want to talk to the board about, which is item I under the agenda. But it's really not associated with it, but we would like under that agenda item, we would like.
We wanted to have a public hearing too. On. That's associated with turning lanes. Correct. Or down at the bottom of Dow Road where it meets 3A.
Yeah, but what would the public hearing be for that?
I don't know if we ever addressed that during the initial public hearing. That there was a possibility that we were going to. Take an additional easement, or I don't know how to describe that.
Yeah, so it is intended that the applicant and the town will work together to acquire those easements.
Yeah.
Yeah,
I don't know if the public was ever aware of that.
it was included in the memo that the notice of decision from August references, and I think it was discussed and somewhat at the August 18th meeting.
We're working through that issue is with the selectmen. Working with the town manager right now on that very issue.
Right.
And preparing a presentation to go talk to the two parties affected by it.
Okay,
So I think that is a town road improvement issue that's kind of with the selectmen. I don't think the need to do it was derived by this board, but the action actually is the selectmen's.
okay.
Like I recall. The issue was discussed.
Mm.
With a public hearing,
Oh, okay.
for sure. Having said that, there were concerns raised that because. That work was not abutting the property, there wasn't notice. To those people. Right
Okay,
now,
yes.
there's nothing for us to do there. To your point, it's in front of whomever. It's not related to the project, but that was raised, so it was a public hearing, that big.
So with this, which we did discuss when they got their approval, which they said they're gonna do the project in phases. But when we approve the project. And to my thought was that we were approving the whole project because we wouldn't just normally approve one phase because, okay, you can build a third of the project and we're not gonna allow you for the.
And some of the
two-thirds.
language supports that we approve
Yeah,
in the.
And could my question was like, can we even do that? Like, can we even take an application and only approve a piece of it?
yeah, exactly. It just doesn't make sense to do that. So what we're trying is just to,
Right, and so at the last meeting, the members that were present at the August meeting, that were also at last meeting, came to a consensus that you had intended to approve the whole application, and then in consultation with council, they decided it would be best to notify the abutters, hold a public hearing, let them speak before you formalize that decision. So that's why you're here tonight.
okay. So we can open the public.
Yeah.
All right.
If I may,
Oh, yeah,
sure. Mr. Chairman, members, again, Andy Perlman, a lawyer with Prunier and Perlman of Nashua. We appreciate this discussion. It's this clarifying this issue is very important, not only to Peter Levine, but to his potential tenants and the lender involved. So that they know the whole project's approved and can just keep proceeding because the demand is exceeding our expectations. Good project. Thank you.
so this is a public hearing. If anybody came to speak about this project, is there where anybody come for this?
Yeah, I did. I live at the top of Clearview.
Give your name first.
Yeah, can you just give your name?
Yep, so McLeod, 26 Clearview Drive, and obviously, what is this project going to affect as far as the Baker Road is concerned? Do you know?
As far as the
Tell me.
The Baker Road?
Baker Road, there's no access to Baker Road at all from this project. It ends, it gets close to it, but there is a buffer. And it does not access Baker Road at all. Does not utilize Baker Road for any purpose.
If you head down Baker Road, you'll be able to get to an open area quicker. Once you get to the property, because there's gonna be development, but it's not access to Baker Road at all.
Can't travel right Baker.
Yeah.
Is it close to the highway?
Can you give your name first, please, sir?
Ryan Salem, 16 Cleary Drive,
The highway,
highway of like 93.
yeah,
Yeah,
you can see it from 93, but it doesn't have any direct access.
So it's just gonna be down road.
Just down road.
That's correct.
And how far does it come to that wetland area?
Going backwards. Where that tree line is now is pretty much it. It will continue in that same line towards Baker Road, but it doesn't go any further back. The whole back end of that property is left. That's it.
Down by that stone wall.
Oh, that's left, yeah.
Is all the clearing done there?
No, we only cleared
No.
for
Okay,
Making a racket.
So this building is up. You've been out there recently. This is the one the foundation is in. I built the board as well. So this one is, the foundation is in, this one, the walls are up. The tree line right now is here. That continues on, but nothing happens up here. at all.
where's the south tree line?
The south,
Like, when you drive in there, how far can you drive in?
you can, they've cleared to this, the third building.
Okay,
Third building is cleared. Now it goes, the current tree line goes up like this.
okay.
So the only thing left are these two buildings to clear. Baker Road. And Baker Road, so. Okay. And there's none of these driveways, these trees along Baker Road will not be access to Baker Road. From this project.
Good questions.
Yes.
That was-
Any other comments, concerns from the public? Now's your time.
Use the same type of construction as the building that you've already put up?
All of the buildings.
Sir. Can we get your name and address?
Oh, Rodney, you said 7 Clearview?
That's not the finished facade, that's just the structural element. That concrete, those are concrete panels. It's the structural element of the wall, it's not what it's gonna look like when it's done, there is something that goes on the outside.
Are those cord or what? The panels that are up?
They're precast concrete. Panels, they come in big
Yeah.
sheets on the truck, and just stand them up, it's like an instant.
I have to say, I was quite impressed.
Good
I
building.
assume they're made in Canada.
Don't know where he gets them.
That's a good
Don't know.
question.
So I take it they went up pretty recently.
Yeah, the building's up, all four walls are up to the first building.
Really? Because I went in there a couple weeks ago to look and it was just a lot of open area.
So what? This has nothing to do with this, but how are those walls going to be insulated?
Must be on the inside, I don't know. An architectural question and I'm not, you just blew by my expertise.
Yeah, I looked at it, but I wondered if they, it was plain to see that they were prefab. But whether they're cord or not.
That's the plate super. He just sits in the truck all the time, I'm sure he loved it.
I've talked to the site super and I don't think that, I think they're 8 inches thick and I don't believe there's any additional insulation on either side that's intended. I think it's the 8 inches of concrete and maybe there's something in the middle.
They're 8-inch panels by 12 by
And it is just warehouse.
35.
So I don't think they're gonna keep them real warm. What are they? I don't think they're gonna be trying to run 70 degrees in there.
Inside the building, there's a mezzanine area that's office space. That it's kind of like a room built inside the building.
Yeah.
For working people. Yeah, so that's probably how they do it.
Is that lit 24/7? Bright lights all night long? Or no?
No, everything will be downcast lighting.
Oh, yeah.
Like any development now have to be all dark sky friendly. That's just part of the ordinance.
Yeah, and all the lighting was designed to not escape the sun. So I don't, anytime you light something, if it's really cloudy, you get some bounce. But generally speaking, you won't, a clear night, there shouldn't be any light escape in the site. You should be good.
Anything else in the public? Okay, I'm gonna close the public hearing. So what do we need to clarify the?
Yeah, and I put them up for you and my laptop. Well, for some reason I didn't print first of all, but now my laptop won't even open. So I would recommend using some of the language from the description here. And so basically, in essence, the motion you'd be making would be to correct the previously inaccurate decision from the August 18th, 2022 meeting, reflecting that the board intended to approve the entirety of the project as opposed to just phase one concept.
So.
That's the essence of what the motion should say.
She said.
Second.
We do that.
We're,
That's good.
Adam,
Adam moved,
Moved it.
second.
David second. That we are correcting our incorrectly,
And then
a previous inaccurate decision. No, we haven't done it.
well, yeah,
And should I recuse myself because I wasn't at the meeting?
you can, I would, if you want to, you could abstain. I wouldn't.
Oh, abstain, right, you're right. Abstain.
I'll leave that same.
All those,
August meeting?
August meeting.
I also was not there for that.
So I
I
can-
also was not there for that, but I am familiar with the issue.
Oh,
I mean,
the testimony last meeting.
you did,
Oh, it was at the August.
Yeah, you were.
Sorry.
Yeah. and you heard it, yeah, I don't think that you have to abstain.
It's a-
Because
Okay,
you-
all right.
You've heard,
that's
you've
fine.
heard the
Yeah,
testimony,
no, that's fine.
we've discussed it in length. All right, so with that, all those in favor,
Aye.
opposed? Abstaining?
No, I just
All right.
said I. would
Okay,
vote
every,
For,
the
yeah.
ayes.
Thank you.
Says you were here. Thank you for that. Can we,
Oh, yeah, so now you wanted to,
modifications?
yeah, that's, that,
Last time I was
Never
here.
mind,
Oh,
Okay.
okay.
Never
Getting
mind.
late.
Brain
it
fart.
is getting late.
So I'll be quick. This is, real minor modifications and actually pretty much a reduction in impervious surface, but so all the pink areas are pavement that's being removed. The green areas are pavement that's being added. This is a shift in the parking lot. So what's happened, in this blue area, the buildings all got, 2 feet, 8 inches longer.
Somebody messed up.
They changed the construction methodology and the old dimensions were for steel building and then they went to concrete panels and they had to change the dimensions by 2 feet, 8 inches. That area was pavement and it's now building, so that was trading impervious for impervious. It didn't really make any difference. The other areas out back, they moved the doors in. They realized in the original design, the overhead doors were right on the edge of the building. And in warehouse, they stack things on the walls and they needed.
Yeah, you'd lose your wall space.
So they moved the doors in. And so we didn't need all that pavement going all the way out to the corner of the buildings anymore. So we moved these driveways up to these overhead doors in and that eliminated some of the pavement. We eliminated, we did a transition and riprap instead of asphalt to go for the loading docks, the overhead doors. So we removed some pavement there. Then they also, they moved the doors on me to access the building and they added one. So I had to slide the parking lot over so that I had walkway in front of the two doors instead of the one that we had originally had. And then I also realized, and actually it was with 87 Dow Road. So based on the septic and the public water supply, each building can have 29 employees. So in my grand logic, I gave everyone 29 parking spaces. But a 29 lot parking lot requires 2 handicap spaces. So if you don't have 2 handicapped workers, you don't have enough parking spaces for your employees.
Need
So
30,
with all.
need 32 spaces, because one of those is man access, right?
So we increased it to 31 parking spaces. These I can only get 30 because of the cistern in there. So that's why the green spaces are a little bit bigger than the red spaces anyways. We added a couple of parking spaces. So the bottom line, at the end of the day, we reduced the impervious surface by 13,865 square feet. That becomes green space, which gives us, we have less snow and more places to put it, which is good. All of the reduction in impervious is on the portion of the project, like with the exception of this one. The that flows into that wetland or in the direction of the wetland. So I think that's good. The groundwater protection district is that way. We're reducing impervious surface in the groundwater. So I think it's generally, it's all good. It's not, it doesn't really change the intent of the project in any way. It just makes the impervious surface less. So I hope you'll find that a minor modification.
Sounds pretty minor.
Yeah.
Do we need a motion to? Got that as a minor modification?
I move that we accept the changes noted as a minor modification to it's Amber Bow project, whatever,
203-22.
203-22.
Memorize, I like that.
Yeah, one of those ones that kind of keeps coming up. I'd love to forget that one.
It's a good one.
No, it's a great project. Don't get me wrong.
It's a big project.
Second,
Second.
oh, Michael.
All right, all those in favor?
Aye.
Aye. Opposed?
Thank you, guys.
Keep building.
Appreciate your time.
We'll get out of your hair now.
I'll have to drive back in there, see the building now.
Yeah,
Really?
absolutely.
Is that a 10-year plan? The one you have on the other side?
No, this is,
Go right ahead with that?
that'll be done soon.
Okay.
18 months.
All right,
Have a good night.
Hallwood Drive.
moving on. Application 203-23, 12 Elwood Drive. PGU site plan application for a contractor's tradesman's shop with associated site improvements in general industrial zone located at 12 Tallwood Drive, map 35, block 2, lot 190J. I'm gonna have to stop bringing my glasses.
Everybody leaves me.
I feel bad.
I'll stay for everybody else's.
Want me to stay over here?
Open night. Hey, everybody.
I feel bad.
Nothing exciting. Nothing like the first one. Hopefully.
So in what, I mean, this is on the same street as my business, but they're 200 feet.
It's a personal judgment call for you. There's no real, you don't have anything monetary to gain from it or.
No,
He's truck travel.
well,
That's. That's a tricky.
you know, I am gonna recuse myself because actually today they came in looking to open an account, which,
We did?
yeah.
Oh, yeah.
One of your drivers is in that's, looking for,
Looking for fancy stuff.
yeah, and more cleaners than anything.
Good.
He wants
We
to
want.
take care of your equipment.
That's what I told them to do, actually.
Myself, just because you're gonna be a customer, you're on the street. So. All right.
Okay, thanks.
Sandy has the chair.
Oh, boy. Come back into the hard seat.
All right. I'll just.
All right, all set, Mr. Chairman?
Sure. yes.
All right, good evening, Matt Peterson with Keach Nordstrom Associates, here representing the change of use for 12 Tallwood Drive. With me tonight is the owner, Ryan Fillion. You might have recognized him here. We've been in front of this board over the last year and a half with 48 Ryan Road. We converted the, what was it? The
Freezer warehouse.
freezer warehouse, the chicken freezer warehouse there. And then he bought the piece across the street. As his business is expanding, as he's told you guys last time, he's like this town, he'd like to move up to this location. So he bought the first site, bought the second one. He was gonna kind of go back and forth across the streets. This came available. I think we're all a little shocked, as I was, considering how many times I've played here and coached here and done everything. I live in Henniker, so very close, and he didn't tell me nothing. I did nothing for about a month and a half afterwards. And finally, when he found out he had to come to front of the board here, that he had bought it. I was like, didn't even call me, didn't tell me nothing. So anyway, hired us to get the change of use moving forward here. I sent out what he does here, basically steel frame trusses for the site. Very clean site. The pictures show that. One of the buildings would be for the product that would come in. The next building would be for the production of it. The last building would be for the finished product. And then outside would be storage of just the studs, the finished studs. Basically looking like a car in the parking lot space that was in there beforehand.
But neatly stacked. It's not just a scattered pile of studs. You can see on one of the pictures, you see one of my trucks, how the bundles are packaged. That's how we stock it outside. It's all of the miscellaneous stuff happens inside. It gets packaged up neat, all the work in progress actually gets loaded on the truck, planned on in the third building. And then the outside storage is just all of the, kind of normal stock, 8-foot, 10-foot, 12-foot stockpiles that our customers just buy for their normal everyday business. So all of the dumpsters and the scrap that kind of happens through the course of business gets all put in the back area. You can see kind of in the back, we've put areas for our dumpsters. So keep everything in containers. Nothing gets scattered around as far as trash goes or scrap or anything. It's all well contained in dumpsters and picked up weekly and out of there. Then all of our kind of, what we would call our dirty work, if you will, happens in the middle building and then in the finished good building. So it's still all under the roof. It's all kind of similar activity that was kind of going on before. It's just going from sports to business, but it's still all staying indoors.
So you're doing the manufacturing in the building?
In the center building, yeah.
Yeah. Like packaging and all that in the outer building.
Yeah, all the stuff happens under the roof.
Yeah,
Yeah. So, one building, as you drive in the building off to the left, what we call coil, you'll see a picture of just a bunch of rolls of steel. That all sits inside under that warehouse. Gets pulled out of there, put into the center building, product gets made there, product gets finished, put into the far right building. We stock it, load it, or transfer it out into that center area to be, sold at a later date.
Let's get a lot of steel, like raw steel in then that you have to
Yeah, a lot.
fabricate.
That's the
rolls that you
whole,
see on the-
that's the process, yeah. Buying.
Yeah, these.
Yes.
So that's the second part of the process, actually. The first part of the process, we take our coils in Nashua, and then we cut them down to that size, so. And then it's formed after that.
Just some of the parameters you guys had. It's about 8.49 acres. We got about 70,000 square foot of building existing on site. We got comments on May 4th from staff and stuff like that. I apologize. I've just been behind the 8 ball every single day for the last 2 years, and we've actually addressed the comments that they had. They were addressed on Tuesday in my office. The plan set that I have up here has the comments 90% addressed. We need to work through a couple of them, mainly the big one being that they asked about the gate. I think that's probably for DPW. Just so you all know, we have people that drive in and do donuts in that parking lot right now. So we've got to come up with some kind of.
Yeah, with the weekends now,
Week on that.
there's no weeknights and weekend, people in and out of there to keep that from happening. Now we're a day business, so we've noticed that there's a fair amount of cars coming in and just having some fun in the parking lot. So we gotta block that off.
So we'll reach out and work that. That's the only one I haven't really addressed yet. All the aquifer stuff and stuff like that. We put notes on the plan. He doesn't have any hazardous materials. I put that for you as well. Is what a 55-gallon drum of your
Yeah,
typical, like. your
just
machine
hydraulic
oil.
fluid.
Right. That'll be.
That's inside,
stored and
not
maintained.
outside.
And stored accordingly to state requirements and stuff like that. I didn't think anybody had any major comments that I saw that were outstanding, that were.
I don't know how you addressed it, but I think the biggest concerns maybe from staff, of course, the gate you mentioned, for works as far as how they plowed Hollywood and where they put the snow at the end.
That's what I figured.
They push it all in front of your gate. That's not gonna be good for anyone. So we need to find a way that they can plow tallwood and not dump the snow in front of your gate so that they can turn around, I guess.
It does get wide at the end over there. So I mean, it certainly, once they get down to the end of that road, can be pushing it off to the edges and not really, up to my
We'll work
gate.
it out. We'll work.
Yeah, you'll have to work with them.
There's no way to turn around. That was one of the questions that they raised.
They'd have to turn around in the property. So I think there
Yes.
has to be a discussion with them if they're willing to do that too. And then we got to figure, we kind of had a couple discussions, but that one comment we'll work through and work it out with.
I'm gonna meet with Tim on that.
The other, I'd say, major issue was you had indicated that it was a contractor's yard and tradesman shop, and we felt that it sounds like there's definitely manufacturing use happening, at least in one of the buildings.
Yeah, it looked like your zoning administrator said to change it to that, but that was all still okay. So I will change. We went with contracting out in the previous two. It's the exact same business, so I just copy the notes over if we'd like.
But it is manufacturing.
But it is
No doubt about it.
Yeah, and so one thing you'll notice though is when you switch it to manufacturing, your parking calculations will change.
And I would request a waiver
Perfect.
on that.
We figured we had provided the
Yep.
appropriate number of parking spaces that you needed, but.
Just so the board understands, this project requesting waiver to allow for the reduction number of parking required spaces from hundred and 44 parking spaces to the 82 parking spaces shown on the site. We just don't need 144. The existing site layout has 275, which far exceeds the requirement. However, the current layout is not suitable for the new use of the property. Due to the nature of the business, the applicant requires larger portion of purpose service to be utilized for laydown of materials and truck turning movements and not anticipated need of more than 82 parking spaces. Therefore, granting the waiver would not adversely affect the spirit and intent of regulation or public convenience.
Is the parking calculation based on how large the building is?
Yes.
Mhm.
And its use?
Yes.
Yeah, so
Contractor.
you're not getting rid of the pavement,
Right.
right? It's just not parking. So if you ever change the use of the building in the future, it wouldn't.
It would go
just
more
back
parking
to
spaces.
parking.
Yeah.
Yeah, okay.
And I know based on what you were just saying, that the manufacturing mostly happens in the center building. I don't know if it makes sense to split the use and.
Oh, from a parking calc number, we can talk about
And
that.
it's just to designate what does actually happen in each building, maybe one of the buildings.
So one building being manufacturing, the other two just being storage type warehouse.
Warehousing, storage, and one being manufacturing. I don't, if that's a more accurate depiction of what's happening.
I guess I'd probably leave this from what I've just sat for the last 3 hours here. I'd probably leave it that the whole site is manufacturing and that. So if somehow one building has, well, if you have a leak in one building and you have to change, I don't want you to be under a violation that you didn't meet the requirements. I think all 3 buildings are set up the same way. I don't think that should matter. So I think I'd rather go with the worst that we have it because that covers them. I agree. It would reduce me down on parking spaces instead of 141. I'd probably be asking for, 90 to 82. I think at the end of the day, we have the parking. If we didn't have enough, the pavement's still gonna be there. Something happened, I needed to park people. That's kind of it. I know it's late. We've kind of just listened to a few things for a while there. So you guys have comments or questions? Fire department.
That's what I was gonna ask too.
We talked to them outside before. They were tired.
Well, we timed the opening of the credit account pretty good today then, I guess.
Yeah, he'll be supporting the motion.
The third, is it the third party review?
There you go.
Yeah.
Yeah, that's what you.
Yeah. So the fire chief had requested the third party review for the fire alarm system and for sprinklers.
Ventilation and other life safety issues.
I don't know if you had any comments about that.
I can never go against fire department. Then you never win. I haven't in 29 years.
What needs to happen?
They want to have a check of your internal system.
Oh, okay.
They probably haven't been there since well, they probably checked it every year, I would think, with being all the kids that went through there, but might have been a while.
Whenever they.
Yeah.
they just-
I think with the change of use,
Yeah.
the sprinkler system might need to.
We have to update it anyway. So our sprinkler contractor is gonna be pulling a permit once we get to this part, because we've already talked to him. We have to move a couple things around. We've got doors that are going in and the sprinklers are in the way of the doors at the moment.
They have to flip direction or something.
Oh, maybe type 2. So we'll get, obviously we have a sprinkler company already
Yeah.
moving forward. So yes, we will definitely have them coordinate with each other.
So there's only 2 trucks a week, no?
No. What? For what?
Deliveries and pickups will happen approximately twice a week with flatbed trucks used to transport materials to the site.
Well, that's inaccurate. I don't know where you came up with that one. I think that'd be the,
Not sure where it is.
Some of our,
That is April 20th.
that's more like, every morning, we do quite a bit of volume. There's gonna be a fair amount of truck traffic.
yeah, some of our comments were that the operational brief that we were provided was maybe a little too brief. It didn't actually explain some of the stuff you just said about what exactly you're going to be doing in the building. I
got a
don't
little
know
more.
that you manufacture metal studs because it's a company, but like the operational brief didn't tell us that. So I don't know if you have updated that.
I kind of felt like this was updating that, but I can also update the narrative that I took this all off the internet today and I can put that back into the narrative now because I learned what he fully does here.
It's probably twice a day.
Oh, it's much more than twice a day.
Oh, yeah, all right.
We have
In and out.
8 delivery trucks of our own, and then we have product coming in. You know, quite a bit every day, so. We move, you know, close to 3 million pounds of product per month. So, you know, 45,000 pounds of truck. A fair amount of product.
Does that trigger any kind of like a traffic study?
Well, you had a lot of cars going in and out of there before, you
Yeah.
know, so I mean, you know, we're still gonna have far less traffic coming in and out of there. I mean, I have 8 trucks. I don't have 100 cars of mom and dads coming out of there on the weekend. You know what I mean? It's still, no matter what I say, I still have far less traffic coming in and out of there. Than what was going on before.
I think we'll need to check, yeah, because like you said, the information we had was that it was,
Yeah, I see that here. Missed
we would
that.
need to look to see if the amount of deliveries would trigger a traffic study.
So I just had one other question on the dumpsters out back. And getting those in and out of there. You just looked at like turning motion, because I doesn't look like you can get around this way with the
Well,
yard.
this won't be a one-way anymore, so they'll come in over here on the side, and they've already done this a few times.
Okay.
They come in, they pull up, and then they, you know, they kind of do their maneuvering back here, and then they drive right back out over here. This is far too tight for them to make
Yeah,
things happen. But the 30-yard containers, the straight trucks have no problem driving all the way around. These are larger ones that will be regular 70-yarders, but they drive in very easily right on the side over here. There's plenty of room. All this will stay kind of the way that you see it, you know, open. It's all just, you know, stuff happening. And then once they swap out, they drive right back out and come out the gate and off they go.
there's no. I mean, it doesn't look like you can get 2-way traffic in there, but you can get one in and out of there pretty easy. So,
It's 24 feet wide.
You could, I mean, you know, you get stuck there.
Yeah,
You're not
somebody got
pushing them off the side, you
Yeah.
know, however, you know, there's not so much traffic that there are gonna be a lot of 2-way, you know, situations. And those containers, they get pulled, you know, once a week or so.
24 feet on the north side of the building. Yeah, it's about 26 on the other side, so yeah, 2-way traffic.
is there any changes in like lighting?
No changes on the site, not anything on that.
So you have to decide if the application can be considered complete. Obviously, it wasn't complete a few minutes ago. Was just received a lot of this information now and typically, I believe it's 7 days in advance it's supposed to be.
Well, it's just the way, but I only submitted the waiver request today.
Right.
We've done that many times at a planning board meeting.
So I was just saying that that'll be for the board to determine.
And the waiver is for
The parking calculation.
parking, right.
I mean, if it was something that you need to review, I understand.
Whether or not, well. That's it.
So we need to accept the change of use site plan?
So
Or
you'd
not?
have to decide if you are willing to consider it complete with the materials that were submitted this evening.
We do regional impact before or after, so.
You do it as part of it. kind of.
Yeah, I don't know.
Why would it be regional? I think it would be regional.
I don't know.
Well, I think that would be before you make
Mhm.
your final decision on any approval.
What would be the region?
I don't know about the trucks, yes. How much trucks traffic?
Well, I guess according to what Carrie had mentioned, we need to make it whether or not it looks like it's an issue.
Yeah, you have to decide, say yes or no
Make a
regardless.
Decision one way or the other anyway.
And yeah, Matt agreed that it does not appear to have a regional impact.
I would support a motion to I mean, I'll make one, but I don't want to do that and then close debate, but I'd make a motion to accept that the waiver doesn't bother me. As complete, all right, the accept the jurisdiction of the application.
So yeah, so the two things that were outstanding for it to be considered complete was the parking, which it looks like they've addressed with the waiver. And then the aquifer protection, you said you added notes on.
Added all the notes on the plan that you had to that, and we had checked for the hazardous and all that material. So I guess that's on me for not getting that plan too. I apologize.
So the site is within the aquifer protection district, and in the original application materials that wasn't addressed.
Right. I saw the notes on that.
But we have that now.
He says.
On our sheet too, we, again, like I said, we've added those notes to the plan and stuff like that to meet requirements and outline the options that were there. I haven't seen it. That's for me. I apologize.
I'll second.
I'll officially make the motion to accept jurisdiction as complete. Second.
All those in favor?
Aye.
Aye.
I mean, I'm good.
No.
No, we're just.
Step one. All right, step one.
I know, it's the tease.
So it might be a good time to address the regional impact next.
Where does Matt note that it
Top of 4-4.
proper page for?
It says page 4- of.
Yeah.
The only thing I would add to that is that I understand, any business you put in is gonna have vehicles and that type of stuff that are gonna use your public transportation to get from point A to point B. But as far as just because my truck takes a right or a left out of the site, doesn't usually regional.
Yeah, I don't think it,
Okay.
There's definitely less traffic, you're right, and
what was going on before?
you driving it down.
At 11 o'clock at night after your 10 o'clock game.
Someone want to make a motion? That effect on the regional impact?
I'll make a motion that the project application 203-23 does not have regional impact.
Second.
All those in favor?
Aye.
All right. I guess there are some things in terms of conditions. How we want to go forward, like the third party review.
Yeah, you can go through that. You could open the public hearing.
Oh, that's right. Okay.
I think we got it.
No public hearing, 9:33. 32. Oh,
Yeah, I do have something to say.
Just your name?
So
Yeah.
I live at 135 River Road. My business is at 2 Tallwood Drive. A little bit to address the traffic. Tallwood was, when it was put in, a turning lane was put in. As far as truck traffic, I probably have at least 50 or 60 trucks, tractor trailers come in and out daily. What they do will be far better than when I get out of work a little after 5 and I have to wait longer to get onto Tallwood than I do to get on 3A because of the traffic, which is, wasn't bad, but. And actually now the traffic, even leaving Tallwood is better because it gets gaps in the light at Dunkley. So traffic in the truck, that's what the Tallwood development is. Definitely glad to have them as a new neighbor down there. I think it'll be a great piece and nobody sees them. It's a wonderful place for manufacturing because unless you drive, have a reason to drive the end of the road, which, their neighbor is Clearpro, nobody goes there. They just call them and they go out. The business is down, there is no business that people go visit them.
No retail.
It's services. you know, we're the, even Clark County. We're the one that holds in a lot of. So, yeah, I hope they, you know, go through well and easy and.
Thank you.
Great. Any other public comments? Okay, close the public hearing, 9:33.
I just wanted to look at what triggers a traffic study, just gonna load up over here, if that's okay. You can continue talking, it might take.
I mean, I'm here to say too that, you know, after obviously that one's coming back for a few more meetings, I'm pretty sure. If there's any way that we could do a conditional, if there has to be a traffic study, we're willing to work with staff on it. I'm not trying to hold anything up on it, but that's gonna be an interesting few months for you guys. Dan Muller, I was sitting with the day before, who's that guy's attorney, and ooh, he's probably not gonna be happy with him tomorrow for not showing up.
Alright, so. If it will result in the generation of an average of 200 weekday vehicle trip ends.
I can submit a ITE manual to you that should show that that's under. I can't say 100% because I don't know what the formula is in my head, but 200 is pretty high.
So
I mean, your trucks, you don't have employees once they come in there.
There,
Yeah.
yeah, it's not even that much.
Yeah.
Plus, is it for, what is the fact that it's a change of use? How does that factor in? Like a.
The fact that we're
project.
reducing it, right?
I don't. Think that there's a distinction in the regulation.
It's just any project that has this amount.
The examples of developments that would generate 200 weekday vehicle trips.
Yeah, it's a retail.
Yeah, there's 20 single family. 17,000 square foot general office building. None of these are really,
You need where people like you are coming and going for lunch and stuff like that, and
yeah,
What's a week? 200 weekly trips, what is that?
weekday
Monday to Friday.
vehicle, so.
200 cars coming in and
Like
out.
Market Basket, it's like,
Okay, yeah, you're not.
Right.
A trip, so
Trip is one coming in and one going out. That's 2 trips
yes, the one vehicle coming in and out is 2 trips.
A week.
a day,
Day.
A weekday.
a weekday, Monday through Friday.
Oh.
Yeah.
how many
Is it
employees? are there?
weekly?
We have 3 shifts,
2 shifts.
2 shifts and 30.
Total employees?
No shift,
Yes.
30, yeah. So if they come in, that's 60. Well, it's, yeah, but it's not gonna, and I'll submit the information that verifies it. It's under, it's not, we'd have to show.
But just your point though, or the question
And
that
it's
you
less
made,
than what was there.
yeah, what was there before? There
not-
was far more going on.
Unfortunately, there's nothing in the regs though
Yeah.
that say, at least in the 29 years, it's usually, like you said, based on a new project, just the project.
Right.
You would make a statement that says previously there were 1,000
Yeah.
and now we're at 201, if that's what it really came out to, you know, so yes, I agree with that.
So should we talk about the conditions in the application then? Or the ones noted here?
Yeah, I was wondering whether the checklist requirements had been met. You can kind of X those off.
Yeah, I asked the applicant. I haven't seen them addressed yet, but.
Okay, the northing and easting provided for 2 benchmarks, elevation not provided.
Elevations have been added to the benchmark reference to existing use plan sheet 1, number 1 of 2.
Like when you go through it.
We have a benchmark up here to nail, right there.
And the
Here
north,
you go. Yeah, there's 3 of them here.
and the northing and easting is provided. And the elevation,
Yes. And NAVD 88.
I'm looking at page 3 of 4 from the site plan checklist. Head comments?
We're right, inside 1, 15. Yeah.
Yeah,
So snow storage areas we showed on the plan. This thing. We just put the stream storage. That's what. We shot a huge snow storage area back in here for them. And then some areas down along here. That's an area from here, put them throughout the site.
Yeah, let me just.
And did you address the evacuation and emergency action plan?
So, yeah, so evacuating right access plan not addresses the proposed project is a change of use and will utilize the existing building footprint evacuation emergency action. Continue to be provided in the same manner as was previously. Right? Existing building that's been there for a while, so that was my comment back to you. Just have this. If I had to do some other plan, I could submit a plan that showed where the doors are. Seems a little redundant.
Did you address the stormwater management plan? Whether like it had been done previously for the site?
Stormwater on this site has been in place for, I guess, probably at least 30 years, and you guys probably know it a little better than I do. From the standpoint of that, I did have them clean out the sediment of the detention basins that had never been touched for the last 30 years when we were out there on site. And if you go take a look at, they've all been rip wrapped and cleaned up and actually the way they should look,
It's all redone.
which was really nice. That's one of the first things that I met them on site. So my statement on the drainage would be that it's been operating as is for 40 years, and I don't know of any pollutants or not that have gone down. I would have thought I probably would have heard. So I believe with what we've done that addresses that. And again, I apologize for not having this buttoned up with you. I usually do before I come here. He kind of bought this, thought he could move in the next day and then said, Matt, I need this submitted. Let's get it going. So appreciate the extra time.
Do they need that plan? Is that a requirement to have a stormwater, whether it's was done before or?
Yeah, so Matt's comment was that the stormwater management plan may or likely was already done, and that in the narrative, maybe they could have addressed that, but I don't know if you were able to locate said plan or.
No, I have not.
Is there to meet stormwater management?
Again, I can work with staff to satisfy staff on a plan that meets the intent of the
Age to. Might be nice to just check the box, not a big deal.
Right, and to do, just to identify,
the areas that they are and that they.
and you know, what you did or that it should be done on a regular basis. Something.
Yeah, because this won't have a SWIP or something that he would know to maintain. So yes, having a note on the maintenance of that or something drainage would make sense. Yep.
I don't even think that they're shown on the plan.
What's that?
Are there ponds?
Yep. So. Take a look at sheet 2. You've got one detention pond up in this location here. This is the one that I had him as you go out on site, you'll know this takes a lot of the parking lot across to there. There's actually leaching catch basins on site. I think that was the way they went about it back in the day. This one, this one, this one, this one are leaching catch basins in the front. I had them clean up the shop back out the catch basins to clean them out and make sure they were functioning correctly. And again, like I said, here's the detention pond in this location. And then in the back corner here, this was a catch basin with an overflow and just kind of dirt and grass in there. So again, cleaned up that with the riprap to make sure where all the drainage was going off site. was much cleaner than it's been the last 10 years.
Continental did all the work too, so yeah, no, good crew going in there and make it all looks real good now.
I will say that's a nice thing with Continental. No state roads, if you've noticed, they don't have a lot of bids for stuff, so they're doing a lot of these smaller projects and they come in and they don't mess around for 2 weeks, 3 weeks. They come in and get it done, so it's kind of neat.
Well, we've been a good customer there for a long time too.
Yep.
I think next, go ahead.
Yeah, I was just wondering if we wanted to, I know it talks about missing checklist items. I sort of thought that we might just identify what.
Yeah, I mean, I believe,
Yeah, talked about the operational brief, talked about some stormwater.
Yeah, but we went through the checklist, northern and easting.
Yep.
Elevation. Evacuation, emergency access,
Right,
and
Snow storage areas.
yeah, you went through that.
right. And then there are also the yeah, I guess the other thing would be just the conditions in terms of the third party review.
yes.
Third party, the gate, to work out with DPW. And the stormwater.
Yeah, there's kind of a lot of, would it make sense to just quickly go through all, and then there's a bunch of stuff that's been done, a bunch of stuff that's
Right,
outstanding.
that's what I was,
Maybe can we just go through them and cross out the ones that have been done?
yep,
No.
that's
Yeah,
a good idea.
I don't understand.
So the first thing is an additional narrative to better understand the proposed use in relation to Aquifer Protection District. Been provided in notes. on
I feel like this. Gives you something to look at. I can do a narrative too, but I think that's a better understanding of what we got there.
I'm looking to you folks that say. Not check, but I'll just read through the items.
Yeah, I mean, basically, it would be what there is that might be a hazard and how it's handled, and said the one can,
So can we talk at all about what is gonna be stored outside?
Yeah. In that picture that shows you with the, on a truck,
Second page,
oh, well, neatly organized bundles. That's really that's what it looks like.
those are
There'll be a
the,
lot of that that's stored outside. It's organized, not scattered. It's segregated piles. Basically, what it would really is just gonna kind of take the place of a car, because it's just being stocked outside and kind of in its own parking space, if you will. Generally the same thing.
Doesn't have any like, I don't know.
There's no runoff on it. No, there's when the rain lands on it, there's not like, any contamination that happens in the process.
And is there any fencing? So we have the gate proposed, but there's no fencing around the laydown area or around the site.
Not right now, there's not, and I wasn't planning on doing anything.
Okay, yeah, I think one of the concerns about the gate was, is it going to be effective if it's?
well, the point was if they want to work that hard to go around the,
I always say it takes a lot to take our stuff. And so,
it's.
and if they start to go around, they can get caught in the sand and they're gonna, get hung up over there.
Without the gate, they can drive a truck and eventually load a truck and drive it out. If they have to move around a gated part or so. It's a good term, but we're gonna work through that with.
So I think number 2, switching the use to manufacturing, it sounds like that's addressed, and then the parking spaces associated that are in this waiver request, which you'll need to consider. The hours of operation, have those been added to the plans?
Yes. Those have been added to. This side. Hours of operation, man, no, 18. Hours of operation Monday through Thursday, 5 AM to 2 AM and Friday, 5 AM through 5 PM. So Friday, that third shift doesn't work. Second shift, sorry.
No third shift.
No third shift. Gotcha.
And then professional stamps and signatures as well as owner signatures need to be on the final plan.
Yeah, that's.
Just a standard condition, I guess. Waivers and conditions will need to be on the final plan. The notice of decision will need to be recorded. Just the department head comments is working with Public Works on the gate. And I will just add that potentially working with fire in addition on the gate because it's their concern as well. About getting the knock
Getting through and then if it has.
box on it. And then also it becomes a fire concern if the snow piles up in front of it because they can't remove it. So so they're interrelated.
Agreed.
And then also from fire is the third party review for sprinkler, alarm system, ventilation and other life safety issues. So that's one of the major conditions probably. And then changing the use, we already addressed that. The checklist items 1, 11 and 15. The one was adding the elevation. We did that. The evacuation and emergency access plan is. Did you just address that orally or is that?
That's what I was leaving it, that the existing buildings are, I mean, I'm assuming they already know where the doors are to get in and out of it that they've been doing for a while. So that was my point. I wasn't gonna tell them where to go access it, but
Touch base with Lee maybe, or the chief. I don't know.
We could add that.
finalize coordination with the fire chief that he's good with the access.
We could add that to the list of things to coordinate with the
Yeah.
fire chief.
I appreciate that.
And then the snow storage has been documented on
That on the plan, yeah.
So the parking requirements are being addressed by this waiver request. We've already talked about the aquifer protection and then stormwater management plan. So the condition would be something about
I would add notes to the plan that outline what the drainage on site is, how it's being utilized and how it should be maintained.
I was gonna say like an O&M notes.
Yes, yep.
What do the regulations say that a stormwater management plan is? Is it?
For me, on new sites, it's an AOT stormwater design and outlines everything that's there, so. And
Yeah, I mean, I don't think,
as I come up with a new project, a change of use, that's why it's
yeah,
kind of was in between two things here.
we can
can't, yeah.
look to see if we have something on file from previous use. I don't know if we would or not.
Yeah, I mean, I think the biggest thing is at the end of our AOT, we have a whole one page that has, you know, how many times a year it should be maintained. When drainage should be directed to it if it's new. Obviously, this is a new, but those type, if I pull out those notes and put those on this plan, they're only gonna be a short little section.
you didn't have to do an AOT for this, did you?
No, because this doesn't have anything with that. They might have back in the day. I'm not sure how long ago this was. Well, it would have been site specific at that.
Yeah, pre AOT.
Yeah, it would have been pre.
That's right.
But yeah, I mean, I don't know, I feel like when I did that solar project, it was like a paragraph. It wasn't like anything
Right.
like.
I can make sure we address it with her.
We already went through that. All right,
We had to vote on the waiver request separate.
yes,
Yep.
you'll want to do that first because you can't
Yeah,
approve it without that.
I'd make a motion to approve the parking waiver.
Does anyone want to review it or I can read the?
Well, we talked about the number of spaces
I
and
did read exactly that into that.
And that's based on all of the square footage being manufacturing.
all those in favor?
I,
You got a motion in a second on that? David.
Yes.
Okay, good. Oh, and the other thing I didn't, you were going to do something about addressing the not need for a traffic study.
Oh, in the comments, I was gonna get you an ITE manual that shows we're under the 200 trips per day to verify we don't need it. Good call.
So do you need me to recap all the potential conditions?
Well, we have the aquifer protection, just to,
I believe that's.
that's on the map.
Yep.
Okay, I guess it's more, it may be more the hazardous materials.
I think that's been addressed already.
Yeah.
Was, I know it's
I don't
written up.
think you want that on the plan necessarily, but yeah,
It would be typically.
it's the narrative. Yeah, yeah.
It's the written,
I'll put it in the narrative cleaner.
right, that's.
Clean up the
right.
narrative. Yep,
And the operational brief, I mean, it could be
that'd be the same.
in there, yeah.
Or the same thing.
Yeah, we talked about the stormwater plan description for. We talked about the third-party review for sprinkler alarm system. Work out with DPW, the gate issue and plowing.
Yep.
Snow plowing. Was there still,
We put the Knox box on there.
Yeah, so all of the fire department issues.
Yeah.
Include the Knox box, third-party reviews, and addressing the evacuation and emergency.
right, I was just looking at the checklist item, right? And okay. And I think that's,
Did you say the notes on drainage?
I did say stormwater plan description, kind of O&M.
Perfect.
It's not a motion.
Well, hold on, you didn't get manufacturing update from tradesman shop that you didn't.
Change.
That's been addressed.
You already did it? Oh, I didn't know you already did it. Okay, never mind.
When it can manufacture.
Okay. So those are all the conditions.
Right. I want to make a motion.
I'll make a motion to conditionally approve application 203-23 with all of the conditions as previously listed by Chairperson Crystal.
Second?
Is it because the proposal complies with the zoning ordinance? It's like.
It is because it comes, yes,
Oh, yeah.
yeah. Yes. Just the language that's written there, but yeah.
Second.
You second?
Sure.
I had asked if there was a second. All those in favor?
Aye.
Great.
No, I'm good.
Hey, thank you very much.
Thank you.
Appreciate it. Have a good night. Good luck with everything.
For soccer.
I think there's one in Hooksett, right? Big balloon in Hooksett that's.
So,
Didn't it?
No, that was Milford.
Oh, okay.
No, yeah, Goffstown deflated.
Goffstown
Milford.
deflated. No,
No, no,
Goffstown
Milford
deflated.
deflated also.
Yeah, Milford.
Oh, cut it out.
Yeah,
Goffstown deflated.
this
like-
year. last
Oh, I
couple
thought
weeks.
that was the one in Milford that went down a
Milford
couple weeks
did.
ago.
No, that was Goffstown.
Oh.
Yeah.
Either way,
It's back up.
I tried to call the guy before we got rid of all the fields to see if he needed it for a little while. You know?
Get the Pembroke one done then.
Yeah, so the end of Manchester Street where the Dunkin's and the liquor store and the sub, right, that intersection. I got a client that's trying to tie it. The owners are, but that's what they're thinking. They're trying to put one.
Nice.
We gotta find something.
Are you down there?
Well, I think this one was, quite honestly, these floors, if you played here,
Yeah, not great, but still.
I know, it's good to go. That's the point where at 53, I couldn't play on the field.
My guys are asking.
We do.
The road standard.
Oh, you guys still doing?
Next time. No new business. Why?
Get that, if they want to go.
And,
What needs to get done?
but anyway.
I don't know.
The road standards.
Approved.
Make a motion. I can't make. motions.
Wait, there's one thing that
I
we
should probably
have.
look at it.
I think there is one thing.
Okay, great.
There's one.
Yeah, we need to figure out one detail.
Okay.
Back.
Thanks.
We need to, why is this pressing? What's happening that's making?
So any new subdivision applications that come forward? I imagine you would want them to be subject to the new requirements of.
Yes.
I have a question again. I think it's, I can't think of whether we've really addressed it or not, or why it's back in here, but on C, street and right of way width and design, under table of geometric standards, under the text, it talks about the 200 feet and the closed drainage being required.
I can address that if you'd like.
Yeah, thank you.
So at the previous meeting, it seemed like the consensus of this group was that you wanted to remove it. I spoke with the town manager who had some concerns for maintenance, and then also when I spoke with the Jeff Adler from Du Bois and King, who's been consulting on this project, he strongly recommended that the language remains. And I tried to rewrite it two different ways. But it's, in the end, it's a policy decision for this board to make whether you want one of these options to remove it entirely. But the question is, when I spoke to the engineer, he said that when frontage is less than 200 feet, meaning that driveways are close together, that open drainage doesn't work, in his words. And
I don't.
that, so those are the words of the engineer, and that's why his advice was to keep it in. And then as far as maintenance from the town's perspective, it can be difficult to maintain when they try to squeeze in the open drainage into those small areas like that. Water ends up in people's yards and they don't necessarily like it. So that's why those options are there for you.
Yeah.
So for me, I think that it's supposed to be geared towards like the open space.
Right.
Developments where you've got like houses with hundreds of frontage. So I personally think that the second one is, you know, a lot more clear. And I don't see why somebody couldn't request a waiver if like every house was 200 or more and there's one that's like 190.
Yeah, I guess I just have an issue with requiring closed drainage. I just don't think that's the way to go. We shouldn't be encouraging it. We hadn't encouraged it for years. And then now that Cherry Hill has come in, you know, they've been the ones that recently have done the developments with curbs. And previously it wasn't that way. And I just don't think that we've had problems with it. I don't think that open drainage has to be a problem on shorter frontage.
I think one thing to keep in mind with that is that if you remove, you know, I gave an either or, but there's also the option for neither. And if you decide to remove all of that language, I guess it would leave it open to the applicant to propose which type of drainage they want. And I think it's probably important to for this board to require engineering review or some oversight, even if it's open drainage. To make sure that it's gonna work appropriately,
Right.
whichever.
And I agree with entirely.
I'm gonna go with the engineer's recommendation.
I guess I'm okay with taking it out together.
When I asked the engineer, I said, so you're saying that open drainage doesn't work or doesn't work well, I guess, when the frontage is less than 200 feet. So is that self-policing? Do we not need the language if it doesn't work? And he said, well, and developers always trying to do this for the least amount of money as possible. So they'll find a way to put it on a plan, but it might not function well in real life.
Well, that is why we need engineering review when we do it. So open drainage systems get reviewed as well as closed drainage
I think
systems.
that's key.
So I think the engineering review is more significant than saying that, you can't have closed drainage.
So would you just replace that language?
Just eliminate it entirely.
But how would you require engineering review? Somewhere else?
The board decides for each application. That's kind of in a totally separate area.
Well,
That,
yeah, the problem is sometimes it's like, well, alteration of terrain is looking at things, which they look at things, but sometimes they've kind of, oh, it was close enough for the rounding or something. And here we kind of said, no, it didn't meet that number. So.
yeah, so there's a separate section of the regulations that allows the board to require that third-party engineering review. And I think it's up to you folks to decide on each application whether that's required or not.
But the applicant knows up front.
Yeah, see, it would be good to say it's required, and then they can ask for a waiver.
Yes. So I'm okay with it.
Yeah, I think so too, because every time we invoke that provision, the applicant loses their mind.
Yes.
Because reasonably, they don't want to spend the money.
Right.
And they are like, well, you don't have to do a school study. You don't have to do this. You don't have, that's what they always say. And they're going to say that here too.
Yep.
And 2 years from now, we're going to say, shoot, we don't remember why we required that, or it's going to be the same issue that we run into.
Yeah, so yeah, I think the predictability is good. You ask for it. If they want to ask for a waiver,
There you
we
go.
can then
Yes,
take it up
Yes,
as
yes,
a waiver.
yes.
I think
Can I borrow some of the subdivision regulations? Because I think that
Yeah, and how does that work with? Like a new subdivision, that's easy, but what if it's just one new lot being created on an existing road? We're now saying, oh,
Well, you
you're doing a
wouldn't-
drainage study?
Well, you wouldn't be dealing with a new street,
Oh, that's a new, only. for-
right? I mean, if you had one lot,
Right,
I mean,
okay,
unless you're subdividing it or doing something
Yeah, yeah.
else,
I get it.
it doesn't even come to us.
Yes, there's a whole section 9 is about inspections and performance guarantee. So I think if you wanted to try to make it more like require that engineering review, I think it would go in that section 9 instead. Trying to figure out
This
where.
is on performance. I think.
Right.
Review it as a It's a plan.
Yeah, so are you saying you'd want to put something in this section on the design standards that says it has to be go through third party review, or would you keep that in the?
Yeah, why don't you just say, when frontage for any lot in the street or block is less than 200 feet. The drainage plan has to be reviewed by an engineer. Or town engineer. I don't think-
We would probably,
Well, the town engineer is usually the party that does the review.
They would do it anyway. That's what you're saying?
Well, no, it's a third, I mean, we call it third-party review.
yeah,
It's
so
our
the town engineer, as according to the regs, always gives comments, but then whether we like. Ask for an escrow payment and they actually do like a full review, that's separate and only done when the board requests it. So. Do you want to call out specifically those subdivisions with smaller lot frontage? To require that review for certain?
Well, if it's saying that for. Over 200 feet, he doesn't matter. He says open's fine.
It still has to be done right, regardless.
Yeah, I mean, that it really depends upon. You know, we often look at how many lots are in the development, in the subdivision. I mean, if you have 2 lots, well, I mean, they're usually not gonna have less than 200
Yeah,
feet.
well, yeah, I mean, you're looking at open space development.
Right,
Which is
yes.
pretty much gonna be 10 lots plus, right? I mean,
Multiple lots.
you're gonna have,
It's gonna go for engineering review anyway. I just don't think,
I mean, you start,
you know,
yeah.
this
you're gonna
language
have-
is needed there.
It's gonna be a substantial subdivision.
Right, right.
So it is really, I mean, for open space.
I mean,
Subdivision.
if there's some place where we want to put about engineering review, I don't think it's
I don't.
in this section.
Place.
Okay, leave this verbiage as is, but
No, take out the 200 feet stuff.
And really, it really should be part of the open space subdivision, because that's the only place that we have under 200 feet of frontage.
maybe,
In with a new road, yeah,
Currently.
currently.
maybe.
Yeah,
We can waive that, though. We've waived it 2.5.
yeah.
Yeah, and I mean, when they're putting in a new road,
Yeah, it's gonna be open space.
yeah,
But when the developer goes through the documentation, he's gonna see this. So he knows what's coming.
Well, I think it just needs to be someplace. I think we need to take away this requirement for the closed drainage, but figure out the best place to put the engineering review.
And I will say that we have a whole list of other potential amendments to the subdivision and site plan regs. We just wanted to get this one done first, so
Yeah.
we can make sure we can put that requirement on our list and
Yeah.
find the proper location for
Right,
it.
right.
That will be
Then
working.
why don't we leave this in here and we can always amend it if they determine that we can put it someplace else. Because between tonight and the next couple of weeks, we're gonna have a development come in, right? So,
Well, actually, didn't we have one just come in?
yeah, that's what I mean. So I want something in here that addresses this problem.
Yeah, but I don't think there's been a problem. I think they just. I know it may be his professional judgment as an engineer. But I don't think we've had problems with open drainage with,
This language originated from the Hooksett regs.
Yeah,
It wasn't inserted here to address a specific problem we've had. here.
yeah,
Well, there's
don't,
gotta be a reason it's there. Like, we can always amend it.
yeah, but,
What's-
yeah, well, I can also just vote against.
You can do
I
that.
just-
You can do that.
Because if we're gonna leave it in, the second one's much clearer to me
I agree with
than the first. So I would say I agree with Mike, and I don't get to vote, but leave it in, and then once we find another place to put it, then we can make a
Insert it.
change. But if there's no reason to leave something vague, then we can make that change later. So.
You good with that?
Would you make a motion on that?
Yeah, so I think someone should spell out very clearly that amendment and then make a motion to, well, have to be a public hearing first, so.
Yeah, we
from
have to
that,
do the drawings.
yes.
Okay, since this is a public hearing, I'll open this to the public if anybody back there has any comments. No.
The closet doors, no.
Yeah.
So-
Not
They've been waiting all
not
night.
seeing any, I will close public hearing.
So we did make all of the corrections that were identified at the last meeting and Adam reviewed as well.
Making the road bigger.
Hmm.
Much bigger.
That's the full chat about it, right?
Like 4 feet. Well, look at
Yeah,
the
4 feet,
definition
4 feet.
because the open drainage is the same size, I believe.
Yeah.
It's just the
So it's-
closed drainage.
20,
So it went from 12 to 18.
so, well, no, so 22 to 26 is the,
Oh, okay,
for a subdivision, it's gonna be a local road.
right, oh, okay,
So,
right.
yeah, for. For the border, then from going from 11, I mean, 22 to 26.
And the amendment you were saying needs to be clear is just which version of the language we're using.
Yeah, and eliminating the redundant one.
We do an amendment separate, then just a vote. For approval or all together. Probably separate. So like I would,
Yeah.
I would make a motion to amend
Yes.
this. Section 801. C1. To strike. If lot frontage is not at least 200 feet for each lot in the street or block within the development, closed drainage is required
That's not what it was before.
and or.
But that's what's,
But this is how this was advertised.
yeah. that's
Yeah,
what-
then we're gonna vote on
in
this.
proposal.
So the motion would be to strike that sentence and the word or.
Yep.
Leaving the rest. That was.
Oh, second.
All those in favor?
Aye.
Aye, opposed?
Me,
So now with the amended language, we can approve this. I'd make a motion to approve updated road standards. As amended.
Second.
You got that, Adam? Or-
Mike,
I could quit.
I don't care.
that was
Whoever.
emphatic.
All those in favor?
I,
Aye,
without
opposed?
opposed.
Public.
Yeah, so
Election of office.
yeah,
we got time.
We have,
Well,
and if we have until like August, I think, to do the election of office.
Okay,
So
all right,
if you-
so for that,
If you'd like to continue that, I would support that decision.
yes.
motion to continue the election of officers.
second,
Wait a minute. Who was that?
Me,
I know.
Mike, Sandy,
All right, all those in favor of
I,
aye.
aye,
Aye.
opposed? All right, we'll do that vote another day,
All right,
non-public.
is there a motion? Yeah.
Why don't we finish our regular business, then go into non-public, then we don't have to reconvene
Okay, what else is left?
Okay,
minutes.
Oh, sorry, I just want to go.
they look, I wasn't here, I thought they were great.
Well, you have to come back in, but we won't have any business. to come
Correct,
back.
yes.
No,
Yes.
that's,
It makes it a little bit,
I agree.
Ginger, these already have my comments in it, right? I just don't want to be.
oh.
Now my water.
Oh, bad memory.
All right.
Where's the changes in mind?
Motion to approve April 20th, 2023 minutes. Second. As submitted.
Wait, who was the second?
Michael.
Aye.
Like,
Thank you.
all those in favor? Aye,
Aye.
opposed.
Does anyone-
That is the easiest minutes ever.
I'll abstain because I wasn't here.
Okay.
You catch that?
Private.
Somebody.
Motion to go non-public session for discussion of
Discussion of,
attorney communication.
Real quick, these non-public meeting, minutes, are these part of the minutes, or are these separate?
They're separate minutes and
Oh,
I don't,
did I?
Only if we take a vote.
The non-public minutes, do they need to be approved?
in
We
Salem,
didn't have a second yet, right?
no,
Okay.
Wait a minute. Is that what we're talking about?
yeah, we're.
We can have a second.
we can do a second and then have the discussion, yes, but. When I was in Salem, the boards would vote to accept the non-public minutes as well, but what I've heard is that isn't customary here, I don't know.
Oh,
There was no vote. So there was no need for minutes.
Well, but you have minutes that you went into
Yes,
non-public
yes.
and that you came out, but there's
Okay.
no decision made.
Correct.
Right, when, I don't know, in Salem, the boards would all accept them like the regular minutes, but I haven't seen that here. So it's not required, there's. So it's just a matter of opinion, the select board doesn't, and I don't think we need.
There you go.
Don't want to.
So we have a motion
Going to
to go
non-public.
non-public. Who's second?
And then we have to
Yes.
do roll call.
Mike,
We need-
how do you vote on?
Aye.
second, I'm sorry.
Adam, Mike is an aye. Adam? David,
Aye.
Michael,
Aye.
Sandy,
Aye.
myself, aye.
Do we? Recording?
Turn it on mute.
Yeah, we're gonna stop.
I'm gonna stop there. Oh, say that we're not gonna be returning to it.
Why not, right?
Okay, okay.
We're not returning.
To the other, to the none other people on the line. Let